welcome everyone to this Saturday, April 17th, 2010 edition of Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Christian Walters, and welcome to NTT as New Trust Technology also. Tonight's show, I'm entitled tonight's show, What Type of Estate Are You Holding Property? What type of estate are you holding property? Or what kind of estate or freehold am I granting, or what kind of estate am I holding real or other property in? Is it equitable trust, common law trust, statutory trust, versus debtor-creditor relationship, which is all commerce, including all of the relationships associated with it. Examples, agency, administrator, leases, bailment, all under the estate of debtor-creditor in commerce. Then what law form it is to the time frame of tenure in prospective or retrospective. Retrospective is saved for unconstitutional means, which would be through the extinguishment of rights through prescription. Are they not picking us to grant to uses? Answer, use as trustee sees and considered as legal owners subject to the rents, the fees, the dues, the benefit of another. What then is our status, our position in the relationship then granted? What is the grant and purpose to the thing or the something of the res in application employed for service as to the length versus temporary possession or the season? And the application would be with contract, indenture, or the employed would really be the service. So that length of time versus the temporary possession and the length of the tenure, which is the time span of the relationship. So we've been tricked from the 13th century forward to the present time, and we've been in feudal times in grant to uses as a popular mode of conveyance or method of trust formation of an estate employed and subject to service under debtor-creditor relationship, whether by misconstruement or by our lack of execution in expressing the trust, by not objecting to protect our CCI/trade secret matter, thereby waiving the confidentiality and subjecting ourselves to the jurisdiction of the court and holding a debtor-creditor estate, after the right is vested interest in the estate. A grant to uses, in the hiding the trust you granted them, to the fee-off-fee and fee to uses, or in other words, a grant to the trustee to use where the beneficiary/landlord, he has the right to take the rent or foreclose on the property or the possession for the non-payment of the fee for the use of the estate or the real property held in tenure, which is the time. So we as trustees of possession are held in service or employed by the beneficiary/lord to use the property for a fee or a rent in return for the use/possession. So 3 forms or dimensions of estate. Number 1, what type of estate are you holding property in? Number 2, what type of law form are you operating the estate under? Is it equity versus common law or commercial or commerce? And 3, what type of tenure are we holding an estate? That would be equitable trust versus common law/debtor-creditor relationship. I'm going to be using Back Officer's Handbook of Commercial Banking Law, the 6th edition. If anybody has a copy of that, they can pull that out. But first I'm going to go through some definitions. Black's Law, if you have a copy of that, grab that. First one I'm going to look at is bad faith. Definition of bad faith under Black's Law, 8th edition. Bad faith, Black's Law, 8th edition. Dishonesty of belief or purpose. Dishonesty or belief or purpose. An example is the lawyer filed the pleading of bad faith. number two definition is really under insurance, and as we know, insurance is all about trust because it's got to do with bonds. That little comment there. And then, now, bad faith enforcement. There's in the bullet, it says a counterclaim for bad faith enforcement arises under Section 2 of the Sherman Act. The Sherman Act, that's an antitrust act. Sherman Act, and under the common law of unfair competition. So bad faith enforcement is really coming under a challenge under antitrust. I'm going to good faith. I'm going to contrast that with good faith. Good faith, Black's Law 8. A state of mind. State of California or state of Ohio or state of New York or whatever state of mind you're in. Good faith, a state of mind consisting in one, honesty and belief or purpose. You believe, that's your state of mind. California? New York? New Hampshire? Number two, faithfulness to one's duties. Remember, that's trust/trust duties. Faithfulness to one's duty or obligation. 3, observance of reasonable commercial standards of fair dealing. Sounds like UCC, and that is. But I'm going to show you UCC. All of UCC is nothing but trust. As long as we'll be getting into it, as well as all of USC is trust. United States Code is nothing but a trust. So 3, the observance of reasonable commercial standards of fair dealing in a given trade or business. Or 4, absence of intent to defraud or to seek advantage. So the phrase good faith is used in a variety of contexts, used for enforcement of a contract. And from here on in, I'm going to try not to say contracts, that every time I think of contract, I'm going to substitute the word place of contract to be trust. There are no contracts today. All contracts today are trust, period. So let's go to credit. Credit in Black's Law. Black's Law 8th edition, credit. Credit. Belief. Trust. Trust. That's credit. Number 2, one's ability to borrow money. Isn't that nothing but trust? One's ability to borrow money. The faith in one's ability to pay debts. That's trust. 3, the time that it's all given to a buyer to make the payment is that due date, usually 30 days credit. 4, the availability of funds, whether from a financial institution or under a letter of credit. Example, the bank extended a line of credit to the customer. So what did they extend to you? Credit? They extended trust or belief to you? They extended you trust? Or maybe they trusted your signature to generate whatever it was they're using as they're lending you back as credit. Now let's go to confidence. Confidence, Black Sea. Got contracts. There's a lot of contracts in there. Confidence. 1, the assured expectation. Firm trust. Firm trust. Faith. So a firm trust is confidence. Faith is confidence. An assured expectation, that's confidence. Self-trust. The partner has confidence in the associate's work, for example. 2, reliance on another's discretion. Reliance. Isn't that trust also? A relation of trust. Example, she took her coworker into her confidence. She trusted her. Number 3, a communication made in trust and not intended for public disclosure. That's your trade secret information. That's your CCI. Not intended for public disclosure. So confidence is not intended for public disclosure. Your trust is not intended for public disclosure. And all of USC and all the rules that they got in place, like the Fair Debt Collection Practices Act, the Unfair Advantages Act, whatever act it is, the FTC, all these acts are nothing more than to make sure that you do not breach your trust by you bringing in your CCI information, which is not intended for public disclosure. And all these laws exist to stop you from breaching the trust. Number 2, communication made in trust and not intended for public disclosure. On down a little farther. A lawyer cannot reveal a client's confidence unless the client consents. Is that what you're doing in court? Consenting to reveal the confidence? But really you can't do that because it goes on, continuing on. After full disclosure, were you given full disclosure of the waiver of your rights that if you disclosed it, you would be waiving your rights? So a lawyer, as well as anything else, whatever confidence it is, doesn't have to be just a lawyer confidence or client confidence. It could be any kind of confidence. The lawyer cannot reveal a client's confidence unless the client consents after full disclosure. Were you given full disclosure? Then you can't waive it. So, compare secret. So let's jump to secret while we're there. And we'll compare secret. Secret. Law 8. Secret. Something that is kept from the knowledge of others, or shared only with those concerned. The state secret. The trade secret. Isn't that what confidential commercial information is? Number 2, information that cannot be disclosed without a breach of trust. Do you see what you're doing when you bring your private stuff into open court? That information, it says, cannot be disclosed without a breach of trust. And you're breaching the trust of trustee and going to jail for it. Number 2 again, information that cannot be disclosed without a breach of trust. Specifically, information that is acquired in the attorney-client relationship. Can't be others, though. And that either 1, the client has requested be kept private, or 2, the attorney believes would be embarrassing or likely be detrimental to the client if disclosed. The bullet, under the ADA Code of Professional Responsibility, a lawyer cannot reveal the client's secret unless the client consents after full disclosure again. Same thing again. Client can't consent until after full disclosure. And then it says, see, compare confidence. So let's go back to confidence and we'll go to confidential. Confidential, meant to be kept secret. 2, other relationship, a trust, characterized by trust and a willingness to confide in the other. A confidential relationship between attorney and client, examples. And now confidentiality. Number 1, secrecy. The state of having the dissemination of certain information restricted. So what state of mind are you in? Or let's put this as, what estate are you in? Number 2, a relationship relationship between a lawyer and a client or a guardian or a ward or between spouses with regard to the trust that is placed in the other by the other. It's all trust. You just never really saw this trust. Let's go to Flynn Plan. Flynn Plan. A scheme by which another is tricked for money. Confidence scheme. Also termed faith and trust. Flynn Plan. Confidence scheme. Faith and trust. Well, this is a reverse. Now let's look up special under Black's Fourth Revised. Special, relating to or designating a species, kind, individual, thing, or sort, designed for a particular purpose, confined to a particular purpose, object, person, or class, unusual, extraordinary. There's a bunch of case sites. And it says, as to special, and it lists from A, starting in acceptance, down to UVW, and W being warranty, and there's a full list of everything that's special. And this should run across to special acceptance, special appearance, bail, special count, special deposit, special endorsement, special letter of credit, special mortgage, special privilege, special request, special trust, special verdict, special warranty. All the stuff that we do privately is special. Cannot be disclosed in the public, or you waive it. So we went through some definitions. That's the setup for Bank Officer's Handbook. Specifically, Chapter 24, which has to do with debtor default and enforcement of security agreements. Oh, now, Christian is going to ask me, what's that got to do with trust? Let me tell you, it's got everything to do with trust because the total debtor-creditor relationship is under trust. So the debtor defaults and the security agreement is going to allow the secured party to do an enforcement because he defaulted. Section 24.01, the general rules on when an obligation is due. I went over the other night, the UCC, and there's some big ones in there I had about mortgage under UCC. But really, this is even bigger yet, because this is all UCC is just nothing more than investing on trust, or it's under trust, whichever one we look at it. The general rules of when an obligation is due. Number one, the obligation is based on promissory notes. Number 1A, notes payable on demand. So when a promissory note is payable on demand, the holder may require the maker to pay it at any time. Although the holder has the power to compel payment, the obligor on the note may contend that the holder has a duty not to exercise their power in bad faith. Bad faith. Uniform Commercial Code under 1-203. Now, this is the old version when this was written in 1989. But the new one is really 1-304, good faith. So the code under 1-304 imposes a general obligation of good faith. Now remember, good faith is confidence or trust. What's your definition? Versus bad faith, which is really breach of trust. Bad faith faith is nothing more than a breach of trust. Good faith is the confidence or the trust. And remember that CCI information, and they don't want you to know that. Not in the public. Can't bring that in. This provision has not been applied to demand for the payment of instruments which are payable on demand. I'm skipping ahead. Next page. Talk about a evaluation of creditors' rights and demand of payments immediately. It says here the financier breached its implied obligation of good faith. An implied obligation of good faith? The financier, the bank? They gave an example here in KMC Company versus Irving Trust Company. That the financier breached its implied obligation of good faith. In other words, implied would be the breach of an implied trust, the obligation of good faith, which was the confidence or the trust. In other words, implied trust was breached. And they became liable for damages. And this was based on the loss of the value of the business. So good faith is nothing more than a good faith requirement, or really a trust requirement. And that's what UCC says under 1-304. All of UCC, everything in UCC, has a requirement of good faith. It has a requirement of trust. So, therefore, all of UCC is a trust. Here, I'm going to go to 24.01, Section 2, which is Notes with Special Contracts Provisions. We'll note here, I'm going through this plain. It doesn't really pertain too much to what we're talking about. I'm going to hit it anyway we're going by. Just to point out that everything is special. Special contract here. We're talking about promissory notes frequently contain conditions, and acceleration clauses would be other conditions. Note the note may contain statements to the effect that the collateral secures the obligation, the holder may have recourse against the collateral when default occurs, and if there are promises to protect the collateral or to give additional collateral, the holder may enter a confession of judgment when the instrument is not paid at the time it's due, and other such terms in which the obligor purports to waive the benefits of laws intended to protect the obligor. You can sell yourself down the river by not knowing what you're doing, because you will waive the benefit of the laws that are set there in place that prevents you from commingling and breaching your trust by taking your private substantive facts, your material facts, in the public, and breaching your trust by bringing it into the public. They're trying to protect you. Now I'm going to go to section 24.02, big section here. This is about special duties. Special duties, everything's special. Special duties of good faith and fiduciary responsibilities of bank to the consumer. That's the title of the section, 24.02. Special duties of good faith and fiduciary responsibilities of bank to the customer. So in other words, this is really a trust and a confidence is the relationship between the bank and the customer, and it is a special one. It's a trust. So when default occurs, the bank seeking to enforce obligations against the debtor may encounter claims and defenses asserted to the debtor that the bank itself has breached a duty of good faith, in other words, breached the duty of trust, or other obligation owed to the debtor, owed to the debtor in the transaction. And there is an extensive body of trust law, establishing the duties of the fiduciary to the principal, which have governed some of the obligations bankers have undertaken for many years. Some of them, probably all of them. Now jumping down, number one, the bank as fiduciary, or put it another way, bank as trustee. Fiduciary relationships generally. When one person conducts business for another in a representative capacity, whether gratuitously or for profit, the one who acts for the other is said to be a fiduciary capacity or a trust capacity. Put it that way. called the principal or beneficiary. The relationship. Remember that, the relationship between the parties is termed a fiduciary relationship, or really a trust relationship. Thus, the term fiduciary includes any sort of trustee. Now, why did they put trust in there? Why do they put trustee? Why did they just put trust in there? Includes any sort of trustee, a.k.a. trust, executive, administrator, guardian, receiver, assignee of benefits, blah, blah, blah. Skip the rest. Next page. The details of the duties of fiduciary vary depending on the closeness of the relationship between the parties. The closeness of the relationship? Well, what is the confidence? Does the confidence mean, well, sometimes you're going to betray me, sometimes you're not? The relationship between the parties and the extent to which the principal, and the beneficiary, is dependent on and confides in the fiduciary. In general, however, under the common law, which remember is held in trust, the rules of equity apply. Then it says, these restate the law of the second law of trust. The next page, any property of the principal or beneficiary that comes into the hands of the fiduciary as a result of the relationship must be kept separate. So it's got to be kept separate, segregated, and treated with special care. So it must be kept separate and special care. There's that special again. Treated with special care to protect the interest. The interest, well, what kind of interest have I got? Sure, $50 or $500. No, it could be, I own the whole darn thing. The interest of the principal in the same manner and skill as the fiduciary would use in administrating his or her own property. However, the fiduciary treats property entrusted to the fiduciary as the fiduciary's own property, or mingles it with the fiduciary's own property. The fiduciary is guilty of conversion. Guilty of conversion, breach of trust. Although these duties may be varied by contracts between the parties, and although the principal may relieve the fiduciary of many of their strict duties, no contract of this nature is effective to relieve the fiduciary of liability for breach of duty in bad faith. Let me read it again. No contract of this nature is effective to relieve the fiduciary of liability of breach of duty in bad faith. That's breach of trust. Breach of trust. Let's put it another way. No contract of this nature is effective to relieve the fiduciary of liability for breach of trust done in bad faith, done intentionally or with recklessness and indifference to the interests of the principal. Similarly, a contract term in which the principal waives his or her right to claim any profit that the fiduciary has derived from a breach of fiduciary duty is not enforceable. Next section, B, transactions where bank is fiduciary, where they're saying they are fiduciary, as if they weren't fiduciary as it was. Determining whether a bank is acting in a fiduciary capacity may be a difficult manner. I don't see how. Anyway, the relationship between the bank and the depositor, ordinarily, I wonder why they said that, ordinarily, is that of a creditor and a debtor. Ordinarily it is a creditor-debtor. Why? Well, you didn't do an execution in expressing the trust. That's why. So that's why it's ordinarily a debtor-creditor relationship. Continuing on, not of the fiduciary and the principal, which would be trust. Circumstances exist, however, in the fiduciary relationship will be applied as a matter of law, because the relationship between the parties involves a special confidence. Special confidence now, as a trust, placed in one person in another. To give an example of that, an example is the escrow deposit. An escrow depository owes a fiduciary duty to the parties to the escrow transaction. The escrow depository does not have a duty to others, although under proper circumstances, notice of the interest, now that's the 3-306, notice of the interest of a third party, that would be beneficiary, may justify opposing a constructive trust upon the property held by the depository. special trust, special confidence. Next page, give me a couple paragraphs. Although there is no per se fiduciary relationship between a borrower and a lender, the court said in a case, quote, a fiduciary duty may arise from a business or a confidential relationship which impels or induces one party to relax the care and vigilance it would and should have ordinarily exercised in dealing with a stranger. And that was our case, Bolton versus Capital Federal Savings and Loan Association. But the court noted that the nature of banking involved a constant invitation, quote unquote, to prospective borrowers to place trust in the bank. Let me read that again. The court noted that the nature of banking involved a constant invitation to prospective borrowers to place trust in the bank. So in another case, in Aaron Fears and Son Limited versus Chase Manhattan Bank, the court decided the initial of the bank, when it engaged in business negotiations, had a duty to disclose information to participants in the transaction. Disclose information. I'm skipping some stuff. It said, when the bank had reasonable grounds for not volunteering information so as to protect the confidentiality of its customers' affairs, the court declined to find the bank had a duty of disclosure of. But anyway, not volunteering information, that's important. Protect the confidentiality, it says. That's your confidence, that's your CCI information. Next page. In a California case, the court found that a bank had a special duty to its customer to act in good faith because the nature of the relationship, in other words, the confidence, between the bank and the customer was a special one, like that of the fiduciary, because of the trust and confidence placed in the bank, and because the business of banking is a highly regulated one that involves performing vital public services substantially affecting the public welfare, quote unquote. Depositors are dependent upon their bank to act honestly and competently to protect the funds entrusted to the bank. Thus, the court viewed the bank-depositor relationship as at least a quasi-fiduciary relationship, one characterized by elements of public interest, adhesion, and fiduciary responsibility. Because of this relationship, the bank implied the covenants, or implied trust this one, to act in good faith and to deal fairly. To act in good faith and deal fairly. That's UCC. And so may be held liable in tort for breach of its covenant. In other words, breach of duty, breach of fiduciary duty, breach of trust. When it raises first defenses and engages in stonewalling tactics to prevent the depositor from recovering funds lost through the bank's negligence, pertaining to this California case that was decided. Next section, number 2. 24022. The bank's duty of good faith and related obligations. So good faith and related obligations, that's a trust. Bank's duty, that's confidence relationship. That's their obligation. A series of cases, often loosely referred to as the lender liability cases, has sharpened awareness of the bank's obligations or their duties. To treat its customers fairly and in good faith. There it is again. There's the confidence. That's trust. That's in UCC. Treat its customers fairly and in good faith. That's confidence. That's trust. That's UCC 1-304. Continuing on to the last here, it says, there's a jury award, and its loan agreements with the plaintiff was held to constitute fraud, duress, and interference with the business relationship and governance of the company. underlying lender liability. Cases that fall in the lender liability category are based upon a number of different legal theories. One of them would be implied trust. Some of these are new and some of these are familiar common law concepts. Keep it down a little farther, next paragraph. Where there is a general duty of good faith, or that implied trust, in the UCC, which attaches to every contract. Which attaches to every contract. Every contract states nothing more than applied trust. Attaches to the contract and to every duty under it. In other words, every agency connected with the contract. Read it again. There is a general duty of applied good faith, really, in the UCC, which attaches to every contract and to every duty under it. The relevant section simply states, quote, every duty or duty within this act imposes an obligation of good faith, and remember that's trust, in its performance or its enforcement. Remember, this section is under the debtor default and enforcement under a security agreement. So this is intended to be an overarching principle of the UCC. Remember that. It's an overarching principle of the UCC that this is all a trust. It is intended to be an overarching principle of the UCC. What constitutes the obligation of good faith is redefined and developed to some extent with particular provisions of UCC that deal with special transactional matters. In some circumstances, there may be a higher duty. A merchant who engages in a transaction subject to Article 2 on the sales of goods is required to observe, quote, reasonable commercial standards of fair dealing in the trade, unquote, also on top of good trade. That's the higher duty. Next page. Under the UCC, any right or obligation recognized by the UCC is enforceable by action, and that action would be really a deed. Either put in a deed. Enforceable by action unless there is a specific declaration. Remember, declaration is the formation of trust. A declaration in the UCC that limits the availability of enforcement. The type of relief that may be available, whether by nature of specific performance or equitable relief, compensation should be determined by the specific provisions of the UCC and supplemental principles of law. Let's just bring them in under 1-103. First of all, principles of law that the UCC incorporates. This invites actions by agreed parties to enforce the duty of good faith. After they breach the trust, that's bad faith. It's got a duty to enforce that, even if you're classified as the debtor. Further, it leaves open the question of what relief may be appropriate under the circumstances. Given the next paragraph. Says this limitation on damages is not applicable where there is bad faith. In other words, breach of trust. 2 more paragraphs down. A growing body of cases holds that a bank may be liable in tort for breach of an implied covenant. Remember, that's breach of trust, an implied trust. A breach of implied covenant of good faith and fair dealing. The covenant of good faith and fair dealing is not based on the UCC obligation of good faith, but rather it is a tort duty whose origin is founded upon the existence of a special relationship between the parties. Remember, it says it's not a UCC obligation of good faith, but rather a tort duty whose origin is founded upon the existence of a special relationship between the parties. So this special relationship between the bank and the customer is at a checking account with the bank because of the public service provided by the bank and the regulated nature of the banking industry. Now, what is this special relationship and its origin? Well, its origin is what we've been going over on the Monday night calls on the book of Lewin, which is the practical treatise on the law of trust. This is 18 1965 book, 2 volumes. But in there, in the rise and progress of the trust in the introduction, it talks about, on page 2, the confidence in the person, and this law of trust, with respect to fiancé to uses, which is the trustee. It was first held to be absolutely indispensable that there should be a confidence in the person. Remember, this is the origins of the trust that I just read in Bank Officer's Handbook. I'm giving you the origin. The origins of the trust is the confidence in the person or the trustee and the privity of the state. And I'm jumping up to the first paragraph of that, what defines what a simple trust is. It says a simple trust was defined in the legal phraseology to be, quote, a confidence. Right off the bat, it says it's a confidence. Remember what we said about the definition of confidence in Black faith. A confidence, not issuing out of the land, but as a thing collateral, annexing privity to the estate of the land and to the person touching the land. That is to say that the city key use or the beneficiaries should take the profit and that of the tenant, which is the land or the trustee, land tenant, should execute in the state as he should direct, unquote. That's the trustee. That's the definition of a simple trust. It is a confidence. Now, going back from the origin back to the Bank Officer's Handbook. Again, let me read that. The UCC obligation of good faith is not based on UCC unfair dealings, but rather is a tort duty whose origin is founded upon the existence of a special relationship. That special relationship is really the confidence. That special relationship is also private. The UCC obligation is public. So this is the UCC obligation of good faith is public versus private. Public being the UCC, private being the origin founded on this confidence, which is the special relationship between the parties. Next paragraph. Breach of the duty or breach of trust of good faith is but one of the many theories on which recovery from banks from wrongful conduct in dealing with customers has been sought. Some of the additional theories are fraud, both in deliberate misrepresentation as well as for fraudulent non-disclosure, where there is a duty to disclose. Interference with business relationship and theories based on lender control of the debtor have also been basis for recovery. When a debtor becomes bankrupt, claims asserted against the bankrupt may challenge under principles of equitable subordination. And liability issues under where they arise when the secured lender now acts to repossess collateral or to exercise other Article 9 rights on default, where they are not acting according to UCC. Now jumping ahead to 24.03, which is enforcement of security interests under UCC Article 9. Remember, the security interest is nothing more than the confidence or the trust. It's an indenture, really. And the enforcement of that security interest, that confidence, that trust, that indenture, under Article 9. Number 1, default. Default occurs when the conditions consisting default as stipulated in the security agreement arise, subject to the UCC good faith rules. So it says, subject to the UCC good faith rules, the security agreement may stipulate those actions of the debtor or those other circumstances that constitute a default. Skipping down, those past acceleration clauses and things. But these clauses may be exercised only when the secured party, quote, in good faith, believes that the prospect of payment or performance is impaired, as discussed earlier in the chapter. Remember, subject to UCC good faith rules. And that's the secured party. And it goes into repossession of the collateral 2. Talks a little bit about the self-help repossession, and that be done without a breach of peace. That is the secured party's unconsented entry into the debtor's home to retake the collateral. How many of you have been out there and had somebody come and knock the locks off and they try to come in and take possession of the property? So as soon as you held up some kind of breach of the peace thing, they ran off. Next, section 3. Constitutional limitations on secured party remedies. A. Supreme Court due process decisions. So this one is an example of Snyder versus Family Finance Corporation, the Supreme Court. But there was absent extraordinary situations, due process requires giving notice to the debtor and allowing the debtor an opportunity to be heard prior to the seizure of the property. Because the state garnishment statute did not afford these safeguards, the court held it unconstitutional. Let me give some other examples in Fuentes versus Chevron. Now B, self-help repossession and the issues of state action. Under the UCC, upon default, a secured party is entitled to repossess the collateral either by self-help, and when it can be done without breach of peace, or by appropriate judicial action. Go through the customary procedure and all tail. Next page. Giving a couple of paragraphs. The reason given by the courts for rejection of the constitutional attack in this one particular case is that the creditor's use of the repossession remedy does not involve any state action. The due process clause applies only to state action. It does not limit purely private conduct. Does not limit purely private conduct. Because the UCC is a state statute and contains a provision endorsing the self-help remedy, there is at least a gloss of state action when the remedy is employed. The decided cases rejects this line of reasoning, though, but the Supreme Court has not decided the question at that time when this was written. I don't know what the decision came out of that. Didn't check it out yet. Anyway, the court reasoned that the UCC provision only codified a remedy that existed apart from the statute of common law, but the court was careful to add, this is not to say that a dispute resolution between the creditor and debtor involved a category of human affairs that is never subject to constitutional constraints. That policy would be trust. Skipping way farther ahead, the secured party's notice of disposition of collateral should reach the debtor in time to allow the debtor a reasonable amount of time, usually several business days, to arrange alternative financing. Furthermore, the court found that an issue of good faith existed when the price of $1,000 paid by the secured party at the sale was grossly disproportionate to the purchase price of $306,000 for the goods 6 years earlier. How many of you have sold your prized possession and they sold it on the auction block for $100? Well, that is an issue of good faith that exists. And remember, that could be a possible breach of trust. Now jumping to the next section 6, where creditor liability for failure to comply with UCC procedures. Failure to comply with the UCC provisions on repossession and disposition of collateral will result in liability of the secured party to the debtor. The resulting liability of the secured party to the debtor. To other secured parties who suffer loss as a result of failure to comply, the general rule adopted by UCC recognizes that a person who may be harmed by secured party's failure to follow the UCC procedures for enforcing the security interest may have a right to injunctive relief to restrain the manner in which the secured party is processing, as well as a right to recover damages for the loss caused by the secured party's non-compliance. The applicable sections state that when the UCC dealing with default, so disposition may be ordered or restrained on appropriate terms and conditions, unquote. This language, as well as comments, make it clear that such relief may be obtained respectively before the unreasonable disposition has been concluded. So it's in the power of the court to control the manner of disposition to assure its commercial reasonableness may require that the collateral be liquidated in conjunction with the property of the debtor, not subject to secured interest, and the combined liquidation should enhance the value of the debtor's estate for the benefit of all creditors. The UCC rule clearly recognizes the right to damages, which extends to any person entitled to notification. They did it, say. Notification of the disposition of the collateral to any person whose secured interest in the property has been known to the secured party before the disposition occurred. Such persons have a right to recover from the secured party any loss caused by a failure to comply with the provisions of UCC Article 9 on default. The language of this section does not indicate whether the recovery should be based on contract damages principles or negative damages appropriate in tort actions. The general principles of UCC on the recovery of damages discussed here with illustration should apply and will permit the incorporation of supplemental principles of law from outside UCC through 1-103. When a consumer goods are involved, the statutory penalty under the debtor has a right to recover an amount not less than the sum of any creditor service charge plus 10%. And let's skip down here farther. Anyway, certain creditor conduct may even be punishable as a crime. Punishable as a crime. When a consumer is involved, the standards of debt collection practices under the federal and state statutes must be followed. UCC does not provide to obtain the best price, does not in effect itself make a disposition of the collateral commercially unreasonable though. I'll give an example down here up above. For the example, the Consumer Credit Protection Act establishes criminal penalties for exorbitant or extortionate collection practices. Now to 24.04, Special Consumer Credit Rules. Now, these are the rules I was talking about that are actually in place so that you do not breach your own trust, so that you bring your PCI information forward from the private, try to put it into the public. Often there are special rules. These special rules are for the protecting of PCI, not to commingle the private PCI with the public. These special rules that apply to credit practices when the debtor is a consumer, the scope of the creditor-debtor rights and duties in consumer transactions is subject to large or comprehensive coverage in this handbook. Some of the major laws that affect consumer transactions is described in Chapter 26. The Federal Trade Commission has a set of rules governing consumer credit practices, and under these rules, it is unfair act or practice under the Federal Trade Commission Act for a lender or a retailer seller to use instruments or contracts in consumer transactions that contain a confession of judgment or other waivers of the consumer's rights to notice the opportunity to be heard. The rules also prohibit such lenders or sellers from requiring the consumer to waive exceptions that might be available to consumers under state laws from attachment or execution on the property of the consumer. Finally, most importantly, it says that the rules make it unfair trade practice for such a lender or seller to use an instrument or contract that has obligations containing a non-possessory security interest in household goods other than a purchased money security interest, and these household goods are defined to include clothing, furniture, appliances, radio and television, blah, 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 wedding rings, antiques, some jewelry. The FTC rules also regulate co-signer practices and also the assignment of wages and other earnings. That was Chapter 24 of the book, just touching on some of the highlights. The Banking Officer's Handbook of Commercial Banking Law, 6th edition. So again, what type of estate are you holding property? one, what type of estate? Which would be one of the three four dimensions of it. Number two, what type of law form? And three, what type of tenure are we holding? So why don't you open up for some questions? Yes, star 6. State your name, where you're from. Yeah, who's this?
Yes, this is Al. How are you?
Hey, Al, go ahead.
I have a question. If you have had a for sale, foreclosure sale, and it already took place, and the house was sold for $100 at the court steps or bid at that point, is there a way to utilize what you found now to go after the bank for treble damages?
Be executing a trust, claiming a trust, have the records that I could prove the trust, and then I would come in for bad faith. Bad faith would be the $100. Could be collusion involved also in that also.
So what you have to open a case, for damages against the foreclosing party, I guess, in this case.
Yeah, you could. There may be some loopholes for that because it really rests on notice, and if you were given proper notice, there are some loopholes in UCC, which I didn't go into. It was just mentioned right there at the end. But colorably on the public side, you can come at them under the bad faith, and they might not have given you the proper notifications, and if they didn't, then that UCC 9-, I think it's 625. Let me look real quick.
Is there a statute of limitation of that action on my part?
That I'm not sure. There may be on the statutory side.
Okay. Here's something to ponder. Be a good way to help the economy. There's an outside.
If 9.5 comes in where the non-compliance with the article comes in, and if there's any breach under the UCC, you can come under the 9-625, remedies for secured parties, failure to comply with the article.
That will be
you could colorably come at them under maybe the 9-625, but then I would really be coming in because what I'm trying to point out is they're really hiding that UCC and all the USC code is really all done on good faith assumption. And good faith is trust. So here it is, it's all resting on trust. Any kind of breach of fiduciary duty or breach would be a breach of trust. That would be a breach of bad faith. So colorably have come at them something that looks like what they're used to seeing on the public side, but then I would claim and prove trust on the private side and come in for a breach of trust on the private trust. Because basically, these banks have a duty, and they're not doing the duty.
How would you come across with this private trust?
Say again?
How would you come in to sue them under the private party or the private trust in our case?
case, I'd come in with some kind of colorable action on the public side that makes it look like something that they could see, that they're used to seeing. But that would create the evidence of a trust and bring that in through the in-chambers with the proof, the two records prove that there was a trust, and then the cause of action being the breach of the trust.
So you have to go through the in-chambers process.
Yeah. Mm-hmm. But you have to do it colorably on the public side, so you don't want to breach trust yourself because you can't bring in the CCI information that they're trying to hide through the bad faith, good faith scenarios that they're setting up in the statute.
Right. Okay. I guess once you're in chambers, it's going to be kept secret or kept private.
That's it. I guess you can bring your CCI in chambers there.
So when you bring the in-chambers, the process in chambers, basically the judge is going to decide in there, and that's it. That the defendant, in this case the bank, will have to just pay. Or will they have an objection or
well, they may have an objection. In the court of equity, now, if you come in with a breach of the trust, it's presumed that the trustee is guilty. And the onus of probandi, the burden of proof shifts now to the trustee.
And we don't think they want to do anything other than that they're guilty, as assumed.
Yeah, so it shifts. Now the shoe's on the other foot.
Okay, well, thank you. I appreciate that. Okay.
Anybody else? Question?
Yeah, Christian, this is Floyd.
Hi, Floyd. How are you?
I'm fine. I got in a little late. I didn't know if you were starting at 9 or if you were starting at 10. Well, anyway, I got in between. But anyway, I wanted to run this, my telephone bill by you because I wanted to see if I had this thing correct. Am I supposed to put private non-negotiable on the front or not?
I would.
Okay, and then you put private non-negotiable when paid to the order of.
Yeah, I would put an addition in there, something else. I would put in there, private non-negotiable special deposit order.
Oh, okay. Oh, yeah, right. Okay, special deposit. Yeah, I got that in my notes. I guess I don't make very good notes. Looks like two separate things there. Should be one. And then now on my bill, it says to detach and return the remittance form with your payment, make checks payable to Sprint. But then on the front of this, it's got a post office box with a woman's name on here, Carol Stream, Illinois. I was wondering if I should make the check, or if I should make it payable to Sprint, or if I should make it payable to Carol Stream.
She's just the escrow rate, whatever she's holding, or an agent for them who's handling the mail. It says to make it out to Sprint.
Okay, so then I would just make it up to Sprint. Okay.
Okay, so they'll be able to build a Sprint.
Okay, so then I was put private non-negotiable, special deposit, paid to the order of Sprint, and then, let's see, on that side, I would sign my name then.
Okay, here's how I would do it. I would put paid to the order of myself.
signature of myself, huh?
Yeah, put your name in there.
Okay. Yeah, this is the front, but I'm not too sure about the front. I know what to put on the back because we went over that several times.
Right. Because here's the thing about on the front. Any kind of offer that they're going to give you, you're going to pay in their special deposit. I would look at that front as being, that's the check. Yeah, everybody knows what a check is like. Everybody knows that the information is on a check.
Right.
Just take the information that's on your check and look on the face of that offer and see if all that information is not already on there. Any information that is not on there that's lacking, you need to supply it. So you're turning that offer into a check, into a special deposit.
Mm-hmm. You're talking about the bill, or you're talking about
The offer.
the offer?
That's the debt title. Turning the debt title into the asset title, payment. A special deposit order. And I'm going to turn it into a special deposit order or an asset title, an equitable asset title. By making it payable to me, I sign it and I'm going to endorse it. I'm going to turn it into a bearer form instrument and then I'm going to give it to them in the bearer form, already endorsed. I turned it into a security, a special deposit. So my pay to the order line is going to be payee is going to be me, my name. And the signature line is going to be me. I'm signing it. I'm the drawer. I'm the maker on it. When I turn it over and flip an endorsement on it, now I've signed in all three different parties. I'm going to leave it in a blank form on the endorsement. This turns it into a bearer form. When I send it to them, just like I make out a check myself, take it to the bank, and the bank wants me to endorse on the bank. I endorse it on the back, and then they give me, like, say, $100. That's how I get $100 out of my account. Okay. But if I met somebody on the way to the bank and say, hey, would you cash this for me? And if I say he knew me, yeah, I'll give you $100 for the check. He gives me the $100, and he goes and takes it to the bank.
So I leave pay to on the back.
Yeah, but it was in bearer form, and anybody who had it in their hand could cash it. It was cash in its own form, in bearer form, because it had already been made out and endorsed by me. And anybody who had it could do a negotiation for the value of the instrument.
Okay, so that's why on the back of it I would put pay to blank by special deposit then, right?
Right.
Because that's what makes it a bearer form.
Well, I don't put that on the back. No, that goes in the front.
Oh.
Special deposit goes on the front. The only thing that goes in the back is without recourse on the first line. Next line is pay to in blank. Third line is by trustee and your signature. And fourth line is this drawn in account plus the social security number without the dashes. 4 lines, nothing else.
Yeah, right. Without recourse, pay to blank by special deposit. And trustee would be my signature. And then then my straw man with my social security number without the dashes. Right. Yeah. Yeah. No,
That was about special deposit on that side.
nothing about special deposit on that side. Okay. Okay, that's fine. Okay, just pay to blank. Okay, all right.
That side is the endorsement side.
Oh, okay. So that's why I leave pay to open, not because they have to endorse it.
Listen, it's blank. That turns it into whoever is holding it. They're the ones that are the bearer, and it's a bearer instrument.
Okay. So now on the front here, it says amount enclosed, and what they want, they have the amount due, $53.46, would I put amount enclosed $53.46 in there, or do I just leave that open?
Well, they want to know the amount that you're paying.
Yeah. Okay. All right. So then I'll just put that.
If you want to make more than what's paying on there, you're leaving it up to you. How much you want to pay? You want to pay them $10 million? Go ahead and pay them $10 million.
No, I'll just pay them for this month. I won't pay them ahead.
All right.
So they'll send me another one. They'll send me another one next month. So pardon me.
Yeah, they'll send you another bill next month.
Yeah. Well, I'm real interested to see what they'll do here. If they'll honor this or whatever. Because,
let's take the worst scenario. Let's say that they close the account down.
okay.
Are you prepared for that?
Well, quite frankly, I don't care if they do, but if they do, I don't really know what I would do.
Right. Now, so you're signing by, say, grantor trustee on this check. Isn't that your claiming trust?
Pardon me? You broke up there.
You're signing by, say, grantor trustee on this special deposit order.
Yeah.
Is that not claiming trust?
Yes, it is.
All right. He who claims trust must prove trust. Isn't that a maximum?
Yes.
All right. Have you proved trust yet?
Well,
or are you not by the previous colorable contract that is in effect until you claim and prove trust in order to be able to make a trustee payment as office of the trustee of some trust that you pretend to be claiming until you prove it?
right. Until I prove it, they're assuming that I'm a debtor.
Yeah, they're going to assume that business as usual. Aren't you under a debtor-creditor contract?
Yes, I am.
You've got to novate it into a trust and claiming and proving trust first.
Okay, so then I would have to put this on the UCC1.
Yeah, create the evidence that you got a trust and put them on notice.
Okay, so I'd have to go through the UCC1 steps and then.
Yeah, he claims you're claiming a trust because you're writing a check on a trust account. You're trying to make a payment as trustee with trust funds. And you haven't claimed trust and proved trust yet?
Right, I haven't until I noticed the public, right?
Right. Put the notices. Yeah, put the notice in the public. Yeah.
Okay.
UCC1 claiming the UCC3 with the transfer of trust for that property and the two county notices to go with that to form your two records for the claiming and the two records for the transfer.
Well, when I do that, I would make them trustee and I would be beneficiary.
Yeah, that's the way you want to do it. Yeah.
Well, that's the only way that's the only way I would understand it in order to get the benefits of the trust. Because if I was trustee, then I would be liable as trustee to make the payment.
So does the trustee get the bills? Does the trustee make payment? Are you making trust payments?
Well, okay, and I guess I would be making a trust payment. But then they would be beneficiary, right? They'd have to be beneficiary.
In that case, they would be.
is Jeff in Washington.
Yeah, Jeff.
Let me give you an idea, and maybe Christian could comment on it. What I would do is the first time you do it, turn that into trust res. Make that an equitable asset title, and then your next bills that you get, then you can write that money order. So establish the trust first, and then thereafter you have the authority to write special deposit orders off of that trust.
Okay, so then the first time I would do my UCC1 and UCC3, and then I would send this in as what? As special trust res, right?
Right, that's what I say. And
Okay, so
first time, establish yourself as the trust. And then you have, like he was saying, do you have the authority to write a money order from the trust? Well, you don't until you have established the trust. So establish the trust, and then you can write those money orders as Christian has given it to us.
okay, so then as special deposit.
Right.
So that's where I will put my private non-negotiable special deposit on the front, pay to the order of myself, and then.
Now, I wouldn't even use that to establish the trust. Just turn it into what I write on mine when I get it the first time. I just write offer converted to equitable asset title number, and then that number, that's the RA number.
Oh, okay.
For special deposit. So that creates the trust res. And that's what you put onto the UCC1, and then you assign it on the UCC3.
And when you transfer the onto the UCC3, are you transferring the trust res to the company as special as trust res?
Yes, that RA number.
Yeah. In other words, you're making them the trustee then.
Yes.
Okay, you're making them the trustee, and you're the beneficiary. Well, really, you're making. Are you making trustee payments? If you're making trustee payments, you're the trustee. Oh, and you're the benefit. Okay, so then they're the beneficiary. Yeah. Sounds like that's how you're going to speak. If you're making a trust payment. Yeah. Okay. All right. So then the trustee, if I want to make them the trustee, I'm going to make one formation of trust res and form the special deposit and form the trust simultaneously. Because I would be grantor then, granting trust res to the trustee, and that would be them. Okay. Well, they're giving them enough payments to, they set up the trust, who's now the beneficiary being me. And we have to give them enough payments to cover, say, the account for, say, like the next, say, 5 years or so. Well, I haven't even had the account that long. I'm prepaying the account with a special deposit of grantor, transferring as grantor trust res in a prepayment for the next 5 years of service to the beneficiary being me. That way I'm not the trustee. Well, in this case, I think I'd be better to be the trustee because that way then I can Well, I guess even as beneficiary, I could change whatever I wanted to change at any time I wanted to change it.
Yeah, but if you keep changing it around, then I don't know if that's too good. You need to either pick one position, stick with it. You want to be trustee and make monthly payments, that's fine. If I just want to be beneficiary, then I'm going to act as grantor, make one payment, and the rest of them I'm going to make as prepayments to take care of me for the next 3 to 5 years, say, as beneficiary. Because they're trustee now. But once I set it up and continue on the way you set it up all the way through. Don't go changing it around.
Oh, okay. Well, I was just trying to think of if I had.
You think we've gone over on Gilbert? You know, the grantor only has a one-time deal as granting in and forming the trust. After that grantor is done. He steps out of the picture. You got to be one of the other parties. You got to be either trustee or beneficiary. You got to choose which one you're going to do. So grantor steps out then.
Yeah. Oh, I see. Okay.
If I'm going to continue to make monthly payments, I'm going to make monthly payments as trustee.
But otherwise, if I made them trustee and I was beneficiary, then I would just do a one time shot, and I would give them enough to cover for the next 2 years or 3 years or however long it is I wanted to continue this on.
Right. Mm-hmm.
Okay. Now, in the event that I do that, would I? Let's see. I would have to put my. Let's see. Let's see. The way Jeff said, put a one. Just put trust res, or how would I word that?
How would you word what now?
How would I word? Where would I put my trust res? Would I put it on this bill? Let them know that this is trust res, or how would I do that?
Well, just the fact that I put on there private non-negotiable special deposit order, that designates special deposit being as a trust deposit. That's trust res.
But then I have to put an amount, don't I? Well, I know that the trust res doesn't have to be an amount. I understand that. But in this case, well, when would I let them? Well, when would I give them the amount of money, or whatever it is that I'm stating, so that they can have?
Well, you're going to have to give them back. So if it's $53, you give them $53.
But if I was going to pay them for the next 3 years, it'd be more than $53.
Of course, yeah. If you 12 months times 5 or 60 months payments worth.
Yeah. Okay, I'm going to have to think. Pardon me?
How long is the contract good for?
It's a 2-year contract.
I have to go. There's 24 payments.
Yeah, I
can trust that up.
Yeah. Okay. All right. Okay. Well, I'm going to have to think about it so this sinks in. All right.
Hey, Christian, it's JT. Good evening.
Hey, JT.
Hey, Floyd, just a quick comment. I'm good, thank you. Floyd, a quick comment. Carroll Stream is a city. It's not a person.
Oh, okay. I did.
Yeah. Just from the very beginning, it's a city.
Oh, okay.
Yeah.
Okay. All right. Thank you. Well, I guess I'm more than confused. I thought I had straightened out.
Okay.
And for whatever it's worth, I like, and I side with the Christian side, that, you take one direction and you go with it, and no matter what, the trustee is always going to be the guy making the payments, or the guy who is withholding payment because you have a valid reason for withholding payment. And from my thinking, that puts you in a more dangerous position because you could find yourself knowing and understanding that, but then if you find yourself in certain court cases, the court may not want to recognize your basis for not making or for withholding payments. So I think it's more protected if you can to get in the habit of always being a grantor beneficiary.
Yeah, I agree with that. It's just that I didn't know how to handle grantor beneficiary in this case because of the monthly payments. But if I'm going to get them 24 months of payments all at once, then it isn't going to really matter as long as I'm making it for a one-time thing. I was thinking about in the back of my mind, I guess I was thinking how we've talked about being trustee and then going in and then going ahead and making the payment as a trustee. But that works better for court cases than it does for something like this, I guess.
Either way, it's all the same stuff, really. Like JP said, just got to choose which way we understand the best and stick with it. Whether you think it's beneficial, if it's better for protection-wise, you're going to have to just decide on the knowledge if you don't understand which is the best way to go yourself.
Okay. Well, I didn't realize when we were talking the other day that I was going to
unmuted
this on the UCC1 and go through the steps like we had like we were doing.
So if you want to be trustee, you'd have to make informed monthly trust. And every month you'd be terminating a trust and forming another one with the next new bill as trustee. That's the only way you can probably get out of that and be trustee.
Yeah. No, I think
grantor make one payment for the whole life of the contract and play beneficiary.
Christian?
Yeah.
Christian?
JC, what do you think?
Well, I like that for a lot of reasons because the thing I've always had, especially when you walk into a court case and you try and be the trustee and explain, even in chambers, why you failed to make a payment or why you withheld payment, it seems like there's a lot more discretion for the court to disregard your allegations that that there's this bankruptcy in place and that's why you failed to make payments. And so you sort of get into this this proving of facts matter. You are in private in chambers, and even if they do allow you to have it in chambers hearing, I think there's a lot of uncertainty and unknowns with the judicial system that may not allow you to present all of your facts. And the second that you claim that you're a trustee, they might just say, "Aha, all right, well then the case is over. We got you."
Okay, well, I'll do like Trey, and then you'd have to play grantor to make one big prepayment for the whole life of the trust or the contract.
Yeah. Okay, well, I'm gonna have to get my brain around this thing. So, maybe go back.
Christian? Yeah, go ahead.
It's a question about the UCC1
UCC3 on a mortgage case, filling out the UCC1, using the promissory note, pointing it as a trust does. Who goes into box 1?
Oh, JC, are you done? I didn't know. I'm trying on you, but are you done yet?
No, I was done. I just wanted to. I started just to tell you that Carol String is not a woman. That's the most important thing. The second thing, this is my 2 cents about, you have to make a decision, and I agree. You come in as either one or the other, and I've never been comfortable with coming in as a trustee side of it. I'd rather just do the grantor beneficiary side. Okay.
Anything else?
That's it. Thanks.
Come on back in a little later.
Okay, thanks.
Okay. So now on to the promissory note being what now?
The trust res, and you're going to fill out a UCC1. Who goes into box 1?
What's block 1 designation?
Block 1 is going to be trustee with the nomenclature change and stands to read as debtor. Does the bank name go in there?
Who will be trustee? Mr. Grantor. Your grantor, you tell me. Who's going to appoint trustee? Who's going to give trust res to?
Well, with
what's your intent and purpose? What's your intent and purpose here?
Well, the intent is to have the grantor become interim trustee through the revocation of the power of attorney, and then have a successor trustee, which I haven't figured out who that would be, and with the intent to hand the trustee to be in the bank, so that the bank is the trustee with the trust res, and then the beneficiary has the original promissory note. And so then the asset liability side of the promissory note being the trust.
Okay, let's run through this scenario. Who has the note?
God only knows. Those are the beneficiaries.
Okay, who's the last party that have been known to have the note?
The last party is the beneficiary.
Okay, who's the beneficiary?
Thanks.
Thanks, okay. Who was the previous party?
Well, let's call the current beneficiary is bank number 4. The original beneficiary is bank number 1.
All right. So now let's go previous to that. Hey, who's previous to that?
The grantor had it when he signed it.
What did the grantor do with it once he signed it?
It's his title company in escrow.
Okay. Who's the title company?
ABC.
All right, so ABC was the first party said?
ABC is the title company. ABC Title.
So that's party number 1?
Yes.
Party number 2 was the bank?
Party number 2, ABC Title, transfers the promissory note to the bank. Bank 1.
Okay. I'm trying to bring it back to the escrow account to the title company because they're the ones that have the actual title appointment by your power of attorney that you gave the bank. That's what's going to change from there because you got to fire them.
Right.
You got to
Hire who?
who's beneficiary also as trustee.
Hire the escrow company?
Yeah, fire the escrow company.
Yeah, but this is 5 years ago.
Fire the escrow company. They're still trustees.
Okay.
And you got to reappoint a new trustee, being the bank.
Reappoint new trustee to bank. Bank number 4 or bank number 1.
Well, bank number 1, you told me, is the escrow to the title company.
Well, I said that ABC Title is the first party that handled the promissory note after it was signed in escrow by giving it to bank number 1. Bank number 4 currently has it.
All right, but bank number 1 is the first known beneficiary.
Yes.
One the title company gave the note to.
Yes. Correct.
4, is they securitizing give the bank 4?
Several times.
And so,
3 times.
what I want to deal with is the first bank who's named beneficiary, because that's where I want to purchase the title.
Yeah, they're the one.
They're the one on the beneficiary.
They're the one listed as the mortgage deed on the mortgage deed of trust. They're listed as the beneficiary, along with
They're the root of the problem. They're the root of the problem. Pull the root out, and the rest of the leaves die.
Okay, so
You knock out the escrow title company, who was the trustee, by the 9-210 debt validation thing, have the right and authority to revoke the power of attorney that appointed them for the bank, for you, then reappoint the bank being trustee.
okay,
And create that you formed the trust back 5 years ago, with putting UCC 1s and 3s in the counties, creating a record that it's always been being, so you could already prove it today, what you did 5 years ago.
so who goes in the debtor box on the UCC1? The escrow company and bank number 1? And then the subsequent bank?
And then you got to claim them as being the trustee.
And I transferred on the 3 to the trustee?
Correct. Right.
So who goes
Change your information on the 3, except you're just changing the collateral description, from a claim on the 1 to a transfer on the 3.
But they're so different. I have both of them in my hand right now, and really is so much different. I mean, it doesn't, comport one to another. I talked to the Secretary of State at length about trying to do this, and then she, I guess the current record information, box number 6 on UCC1 on the national version, revised, actually 02, this one, it has current record information, organization's name. So she said put same as UCC1 there. So that would be the escrow company and that would be, I would want to make that now the new trustee, right?
What's the escrow company? You ain't got to put it on that forms anywhere.
So, right. So I put bank number 1 as the current record information.
Bank number 1, right.
And changed so basically that's the only thing, and then under number 8, that's where you switch the claim to a transfer, and that's it. You got the same nomenclature change note.
Right. Just you're transferring on the 3.
Okay. Now, when I'm doing this, when did the transfer take place? there's a thing in there, number 3. It says continuation. Effectiveness of the financing statement identified above with respect to the security interest of the secured party authorizing the continuation statement is continued for the additional period provided by applicable law. So do you put down, I guess that relates to the,
there's a block in there that says it's a transfer, and you check that, and it's a partial or it's a full.
There's no, I don't see a block for that. Number 1,
Block indicates a transfer, either partial or full. Full transfer or partial transfer, or assignment.
Yeah, number 4.
oh, assignment, okay, assignment. Full or partial, yes. So give the name of assignee and 7A or D.
So now you're going to do what kind of a transfer?
Full transfer.
Right.
Okay. A full transfer. And then there's the secured party in block 9, which is
No, there's no security on that.
you know, put your
Party in
hand
any of these forms.
in.
There's no secure party in any of these forms. If there is, they're going to change it.
Well, change the optional file or reference data as to trustee grantor with the nomenclature change.
Right, right.
But on the document, we don't want to change that, right?
Correct.
Okay.
We're not thinking these are not secured parties. These are trustee,
Grantor.
transfer, yeah.
Okay. I think I got that. Now, there's when this is going down, and I'm considering my cause of action here. There's 2 cases I found that involve
the cause of action. What's the cause of action going to be?
Well, it's going to be breach of trust. But
Okay. Now, how did you get them in a breach of trust?
well, number 1 through 9-210 under the debt validation default.
It's just the authority to rescind the contract. Once you have the contract up, now you can claim through trust. So now you got a trust. When did you get the breach of trust?
I'll get it next week.
That's something that they breached it. If you don't have the records created for a breach of trust and you don't have a breach of trust, how can you come out with a cause of action and an action for a court claiming a breach of trust?
Right. Okay, so I understand what you're saying as far as the timeline goes. There is
Evidence of what we're doing to make sure we have created evidence for everything we are doing. And all this follows in a logical sequence. And it's really not a lot of rocket science. You just have to be logically minded at it, following a step-by-step thing, and make sure you're putting yourself one foot in front of the other, and you're not taking any 2 jumps and leaving stuff out.
Okay.
Otherwise, you get
I'm sorry, what?
I said, otherwise you're going to hang yourself.
Okay. So, I've got the UCC1, that's step 1, to create the record. Once I have a timestamp and a date on that, then I'll have the UCC3, the transfer. In the meantime, I have a debt validation letter out that defaults on tomorrow. And the following day, I will record the UCC1 and the UCC3 in the county, and I will also record a power to revoke the power of a order to revoke the power of attorney, an order to assign a new trustee.
All right, what's going to be your breach of trust for them?
Pardon me?
What is going to be your breach of trust for them?
So tomorrow we'll have a certificate of dishonor. 14 days that they've had the debt validation letter not responded.
Okay, you're confusing that with breach of trust. That's not breach of trust. That's just they didn't validate the debt.
Okay.
It gives you the power or the authority to revoke the signatures and the power of attorney.
Okay.
Where's your breach of trust?
My breach of trust is in the fact that when I assign the bank as the trustee and they don't make a payment.
You're confusing what we said on other cases pertaining to apples over here, but you got oranges and you're mixing apples and oranges. You got fruit salad.
I'm sorry.
You're talking about mortgage foreclosure, which has got a promissory note, which was made in payment in special deposit 5 years ago, say, and now you're creating the records for it. And when did the breach occur? Breach of what?
Okay, the breach of trust occurred on the day that they received the promissory note.
How?
By me expressing the trust 5 years later.
What's the breach of trust?
I don't know. Well, there's several of them, but one of them is the fact that they violated not answering, title of the debt validation letter, which they're required to do.
It's breach of trust.
That's breach of contract, isn't it?
That's got nothing to do with the breach of trust. That's just debt validation. Gives you the authority and power to revoke the signatures on the contract. So now you've got rid of the contract. Form the trust.
Christian, can I make a comment?
5 years ago on the promissory note.
You did.
The deposit's already been made.
You did.
They did them on a breach on your special deposit on the formation of the trust.
Oh, I'm sorry, my goodness, that's right, thank you. I'm going to order them to pay the debt.
Okay.
And then they're going to renege.
All right.
So I'm going to order them to pay the debt with the special deposit.
Now, where's your record that states that that's what's happened?
UCC1.
3.
Yeah, the 3.
Two records to prove any fact.
Okay, so I've got
Your NOI is that they breached trust. Now, where's my SOI to substantiate my NOI claim? Where's my two records to prove that an SOI?
My NOI was a UCC1, which I filed.
No. That proves that you created a trust and you transferred trust res. Where's the proof of the breach? The breach. Where's the proof that they didn't make the payment? Where's the proof that you asked or you ordered them to make the payment? Where's your facts that substantiate your claims? People, we don't know how to view ordinary government, which is due process, which is a right to have a hearing and be heard, to bring forth your evidence, your records to prove a fact. It's really simple. All I need is two records to prove any kind of claim. But I better have two records. So I need to records that I ordered them to make payments, and they fell down on that fact. And then that was it.
There was static. I couldn't hear any of the last two sentences.
You create two witnesses, two records, or two titles that prove the fact that there was a breach of trust. So then the next step, I could put together a court action, a cause of action in court for a breach of trust. Otherwise, you'd be like filing a case like on a mortgage foreclosure. They don't have all the documents. They're trying to foreclose on you with nothing, no evidence, just copies of stuff. And they're just coming in with conclusory pleadings. But they're much better at hammering you are hammering them. Because you don't have any records.
Right?
You do.
Okay, so my proof that they didn't make payment
Would be breach of trust. But he's got to still create some documentation to show breach of trust.
Right.
Okay. And then the proof that I asked them to pay with the special deposit, that's going to be an order?
Yeah, you'd have to issue an order for them, ordering them to take your special deposit and do a conversion and apply towards the debt. Definition of I believe, trust deposit. Trust deposit is Black's law. For money or property deposits be kept intact and not commingled with other funds or property of bank, and it's to be returned in kind to the depositor or devoted to a particular purpose. So my preferred purpose is the next thing, or requirement of depositor, or payments of particular debts or obligation of depositor. That's what I want them to do.
So I'm going to order them to, what?
Is this the process where you're trying to make the bank the trustee so that it terminates and they got to disperse the funds?
Mm-hmm.
So he'd make trustee because we're like in the next step. They've received trust res, but now we got to get them in the breach, in the breach of the trust. So they are saying you ought to receive the trust special deposit.
It sounds like you're trying to tell him he's got to make some kind of letter of instruction that they have to breach.
Yeah.
Like, go disperse the funds or whatever. Well, I don't know the whole thing, but some of the instructions and then have the instructions. Will you send that along with the UCC1 and the 2?
Yeah, if they've had notice already, I would think I would maybe wait that extra day.
So,
Station. Well, that actually happened years back. So. Yeah, you probably could, yeah.
because that would be that would be actually, I don't know how you phrase it, but just generally, I think I'm following you. So you give an instruction to disperse the funds because you have the UCC1 and 3 as the proof.
And convert into payment of a particular debt.
You don't need more than that. Just notice that you're doing that process, and then I think you mentioned publicly register
order. It's a directive, a command, or an order.
No, but I mean, just get back to the UCC1 and 3. He was saying you create those documents, and then he's going to also register those into the public, to the county.
And also on the formation of trust, that's when trust res transfer to the trustee. And so
service is provided by preconferencing.com. Please enter your access code followed by the pound. This menu will repeat. Incorrect access code. Please re-enter your access code followed by the pound. Contact customer service if you need assistance. Goodbye. This service is provided by preconferencing.com. Please enter your access code followed by the pound. This menu will repeat. Thank you. Access code accepted. Muted.
Yeah, there's no place to get to currently doing calls right now because the site's down, eh?
Unmuted.
Recording them, I mean, whoever needs them, you can share
I'm
them.
going to start. Yeah, I'm going to start. I kind of missed the time again because I got messed up about 7, 9, or 10.
Mm-hmm. Anyway,
You only missed some discussion on UCC and trusts. I mean, if you came in a half hour late, you got the meat of it. Okay. But I still got it. Yeah, I got to get this. I'm familiar with UCC1 just because of Winston's BC bond process. I was actually going to ask if, I wonder if we could just get away with just showing a UCC1 we did on our birth certificate, social insurance, and driver's license and all that. And this, that straw man security agreement. I wonder if that cuts it, right? Because everything's a subtrust under all those anyways, aren't they?
no, because you've got a special deposit that you're transferring to them.
I wonder if, I know this sounds crazy, just throwing it up in the air, but, because it kind of sounds like that's, in a roundabout way, that's what Winston was doing anyways, right? He was putting a lien against the,
in my case, the beneficiary fell down and was supposed to register the promissory note by law, and they didn't. So I'm registering the promissory note myself. I'm going to become a special depositus to Trust Res as the corpus of the trust, and then I'm going to have I wanted to ask him if that, on the...
Is that true, though? When did it come up that they're supposed to register the promissory note?
It comes up under the SEC rules.
Can you guys hear me?
I hear somebody now.
Okay, yeah, I think that comes under 1692, under the Truth in Lending laws, that note has to be registered. But if you go back to the Supreme Court case back in Ohio, the one that set precedents, that means that anytime that they take two instruments and divide them into halves, it completely nullifies and voids out both instruments.
Not only that, I found 2 new cases, Chris, and one's in Massachusetts, one's in Texas, and in both cases, after the foreclosure, the foreclosures were made void based on the fact that the assignment of the foreclosed mortgage by the plaintiff was not executed or recorded until after the exercise power of sale.
So what's the bottom line? Are you saying that they got that means every single mortgage is in some form of default because they didn't publicly register the note? I thought the note's supposed to be private.
Yeah, I sent a letter to the state of California explaining to them, including the county I live in, that every every deed of trust that they've got on file is completely null and void, and there's nothing they can do about it because they did not follow the promissory note with the deed of trust.
Come on, you guys, you really think that they're all wrong, like all 50 million mortgages are wrong, or do you think maybe possibly you guys overlooked something?
Well, no.
80% of them, he's actually correct. 80% of them are.
They actually, I thought the understanding is that they never publicly.
In the commercial world, only 28% of them are. But in the residential world, 80% of them are the way he's talking.
Not registered, right?
Right. And in the commercial world, 28%. That's why they're in better shape, actually. Only 20% of the notes are in commercial mortgage pools are securitized.
Well, securitize one thing, but you're talking about publicly registering it. That's different, isn't
Well,
it?
in order to securitize it, they can't register it.
We kind of had this discussion before you guys were bringing up, but there was sort of like it never got really settled whether there's some kind of process in between, because there was that whole question, how do you take something and securitize it if it's in a special deposit and trust? Unless they do a second step, but maybe they're just working with the derivative off of it or something. I don't think that was ever answered straight. Or at least figure out what's going on there.
Well, the other problem you've got is they never took the promissory note and put it onto a UCC1, and a little bit of what Jacob is talking about is true, that once you go ahead and take that promissory note and put it on a UCC1, as you being a secure party, that locks the criminals, which are the banks, out of having any superseding claim on the property.
Yeah, right, but that's the whole reason why they don't do it. So I don't think there's got to be some kind of legal justification why they don't do it, because obviously
it's admittance. It's admittance.
The whole trust thing would be like they're doing it for you in the first place, you know.
But it disrupts the power of sale.
It's admittance.
Yeah, that's another reason too.
It's admittance.
Actually coming in legally to foreclose because they don't have the execution of the power of sale.
Okay, now we got three things going on. Now you're talking about security, and then you're talking about registering, and then you're talking about doing a lien, like UCC1, notice of claim type of thing. So, I mean, I think we're...
It's not a lien at all. It's just a notice.
Notice of claim. So.
It's a non-UCC filing.
It's a notice of claim, right? Could you call it a notice of claim?
Yeah, it's a notice of... It's a filing of the claim, whatever you want to call it. That's what it is.
Notice of claim, yeah. That's what they call it over here at PPSA. We got
it's a public notice.
Public notice, yeah. But again, go ahead.
Hello?
Hello?
Christian, I cannot hear you. Can you turn your thing up or get closer to the mic? Wow. Are you on the VOIP, Christian?
If you got a bad thing, just, if you're on Skype coming in like that, hang up and call in again.
Mm-hmm.
Yeah, you sound really like you're
Christian, you're at about 15-20% of your volume.
Yeah, you sound like you're in another connection completely.
I'll call back in.
Okay.
Yeah.
Anyways, listen to this carefully. It says, involved in a mortgage foreclosure sale of residential property was noticed and vested by an entity without record interest in that mortgage at the time of the notice of sale. Plaintiff was both the foreclosing party and the only bidder at the sale, wiping out all of the defendant's equity in the properties and leaving with them with a substantial loan deficiency. Plaintiff could not obtain insurance, brought these actions to refile, blah, blah, blah. Bottom line is that the defendant, which is the homeowner, presented the same two substantive issues for resolution: foreclosure under power of sale, GLC 24 Sequetia 14 procedure notice and form. The bank said that they were able to close the property because they gave them notice through a newspaper and did this 3 times, and they filed that they followed the meaning of this notice. And so the plaintiffs then the plaintiff said that they had the right to have now timely moved to vacate that judgment, making they made 5 arguments. And then for reasons more settled forth, each of the arguments failed, and the judge said that I thus deny the motions to vacate. And here was the summary. The plaintiffs cannot credibly claim surprise at the judgment that was entered, and having asked for and received the declaration issues they chose on the facts exactly as they pled them, they have no right to a do-over because the declaration was not entirely as they wished. Moreover, the newly presented facts do not lead to a different result. Instead, and this is the final quote, they show that the plaintiffs themselves recognized that they needed mortgage assignments in recordable form explicitly to them, not in blank, prior to their initiation of the foreclosure process. That the plaintiff's authorized agent argument fails both on its facts and as a matter of law, and they reaffirm the correctness of the original judgment. So that because the bank came in and gave notice, and they used that to cover over their fact that they had the note, which contained the power of sale, they gave the properties back to the homeowners in this case.
What's the name of that case?
The name of that case is
Hold on. The assignment that you're making reference to, is that the assignment Christian's talking about?
No. That's the assignment once they register it with the state, when they sell it, they have to give the person an assignment, and they have to give them public notice. Right, Chris?
Yeah, and that's a big mistake on their behalf, because that's exactly.
Let me finish. That case is U.S. Bank National Association against and there's actually 3 cases. It's a U.S. Bank case, it's a Wells Fargo case, and it's another case. Now I have another case right here, and this one's in Texas, and this says general denial. Defendant hereby enters a general denial as permitted by Rule 92, Texas Rules of Civil Procedure, and requests that plaintiff be required to prove by sworn affidavit and by a preponderance of evidence that their allegations are truthful representations, B, that their action has merit, C, that they are true, and the lawful party of interest, a holder in due course of a valid debt obligation, and their alleged evidence is not a product or preclude to fraud, and that they have legal standing to lawfully invoke the jurisdiction of the court. Number 2, plaintiff lacks standing to invoke to foreclose. Defendant hereby disputes, blah, 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 alleges that there exists a genuine attempt by the plaintiffs to deceive. The defendant is supplying all the necessary facts to prove the following. In an attempt to non-valid debt obligation, the plaintiffs committed irreparable fraud by A, not filing the required notice of assignments as required by the property code. This one's in Texas. B, manufacturing and filing a fraudulent notice of assignment and furnishing it as proof. C, deliberately withholding that same notice of assignment from the court to manipulate, deceive, and attempt to conceal from the court a fraudulent act.
So what's the notice of assignment that you're talking about in this process at this stage?
That's when it goes from bank to bank. If one bank has it, and if Bank 1 has it, and then Bank 2 has it, they have to give them they have to give into the public a notice of assignment that assign the note to a new party.
So that was key to that whole process from why they got turned down, because they didn't make this notice of assignment from one bank to another bank.
No, they got to make it public. They got to give notification to the state and the county that there's a new party of interest that's related to either the deed of trust or the promissory note. When they fail to do that, that's fraud.
If you let me finish, you'll see why this falls into the SEC violations. And that's what we want to get to. That's who runs the world, the SEC.
But so I'm just trying to understand that process there, since you're going to go through it all. What's going on exactly when they're assigning from one bank to the other? What's going on there at that stage?
They're assigning. They're assigning. It's a chain of title, my friend.
Okay.
One party selling to the other, and the other one gets paid.
Oh, but this is part of all that they're trying to move in on.
Not only that, it's a chain of title. They're saying that they're actually the holder in due course from one party to another, which they aren't even that. It's already an electronic note out in cyber SEC space.
Okay, they're trying to make on like they're passing title from one bank to another.
They'll get one to another. When they're doing their books, they're probably using these like a football, passing them back and forth.
Okay. But what are they trying to make it look like, though, really? They're trying to make it look like they're passing the title to the other?
Finish, okay? And then you might be able to...
Hello? Yeah, I just popped in myself.
Yep.
You there?
Yeah.
Allegedly held by the Dutch Bank National Trust Company as trustee in trust for the benefit of the certificate holders for a pass-through account, and are threatening to foreclose on the defendant's property and primary residence. A plaintiff bears the burden of demonstrating standing and must plead components with specificity. Should plaintiffs fail to prove this condition precedent, the court has no discretionary function but to stop them at the gate and dismiss the action. Proof of signatures and status of holder in due course. Defendant claims plaintiffs are without legal authority to enforce foreclosure and so challenges the validity of the defendant's signature on the alleged debt obligation. This is pursuant to the Business and Commerce Code sections 3.308. A, proof of signatures and status as holder in due course, and signature relating relevance to the validity of the defendant's signature on the alleged debt obligation being brought before this court. Defendant does admit that he signed the debt obligation, but the alleged debt obligation in question brought before this court is not the same debt obligation that the defendant entered into. Defendant denies that any obligation is owed to Dutch National Trust Company as trustee in trust for the benefit of the pass-through account. So it boils down to a broken chain of assignments, and it renders the deed of trust void and unenforceable under UCC 3-201, 3-204, and 3-302. And as such, no triggering of the foreclosure clause in the deed of trust is possible, such as the power of sale. So, then we come into the SEC part of it, which is the pooling and service agreement. And there's very specific rules for recording assignments. No such filings were recorded. Failing to record such notices of assignments to the alleged debt obligation in question have created a defective chain of assignments with blatant disregard of code section such and such, which is the validity of unrecorded instrument as verified with a recent title search. So once you do a title search, you have proof of the validity of an unrecorded instrument, right, Chris?
Yep. Yep.
Do you have a notary public do the title search?
There's companies down in Los Angeles that actually will do all the, and they're very thorough. For $75, you can have them certified.
Okay, so here we have the validity of an unrecorded instrument now. A, validity of unrecorded instrument requires that each notice of assignment to the debt obligation in question referenced within the original deed of trust filed in the county records be acknowledged, sworn to, or approved and filed for record as required by law. These codes I'm mentioning here, the property codes, are obviously under federal SEC regulation as well, probably, right, Chris?
Generally speaking, yes, there is a correlation.
I think they're in the back here. Hold on. Research, however, indicates that a notice of assignment of the alleged debt obligation in question should have been recorded in the county somewhere on or before the pass-through certificate was issued. may be found guilty on a felony of third-degree charges, rendering the notice of assignment defective, invalid, and void. Transfer of instrument rights acquired by transfer. The fraudulent act of creating an unlawful document, such as the one created by such and such, defective, according to the code. And B, transfer of instrument rights acquired by transfer. The transferee, the Dutch Bank National Trust Company, as trustee for the pass-through account, cannot acquire rights of a holder in due course and therefore does not have the right to enforce. Furnishing certain deceptive forms in federal laws, furnishing certain deceptive forms, 15 U.S.C. 1692J, the notice of assignment recorded in the county, being used to create the false belief that a lawful act is being executed by persons to collect a non-valid debt by the plaintiffs in response to the defendant's original request seeking to view the alleged original paper promissory note with all assignments and allonges showing a complete chain of assignments and to identify the true owner and holder of the alleged debt instrument. So then we have pooling and servicing agreement and conveyance of mortgage loans. Only the depositor was authorized to assign instruments to the trustee.
Now, wait a minute, Jacob, just 1 second. I want to remind you that when Christian was asking you what is a breach of fiduciary obligations, that is exactly the breach that you should be calling upon.
Right, that's why I'm bringing this up, Chris. I've had this prepared just for that answer, but I wanted to get into letting everybody start working on this because this looks like the key. Once we've got proof that they didn't register it, and then if we just work on proof of the chain of assignments through the securities brokers, we're going to actually have the proof before we have to get them into court with a discovery. We'll have actually done the discovery ahead of time. We probably can call them on their act. It's going to be less likely to think about any kind of court action once we bring that up beforehand. That was my thinking. Anyway, it says that only the depositor was authorized to assign instruments to the trustee, and the pass-through account company was no longer the holder or owner of the alleged debt obligation in question. Dutch Bank National Trust Company and custodian became the reputed holder, and the certificate holders became the reputed owner of the alleged debt obligation in question on or before its official cutoff date. So then under the Securities Act of 1933, Title 15, Chapter 2A, Subchapter 3, we have the evidence of recording of indenture in the Social Securities Act of 1933. Under the Securities Act of 1933, Title 15, Chapter 2A, Subchapter 3, Section 77, CCC, Definition 7. The term indenture means any mortgage, deed of trust, or other indenture or similar instrument or agreement, including any supplement or amendment to any of the foregoing, under which securities are outstanding or are to be issued, whether or not any property, real or personal, is or is to be pledged, mortgaged, assigned, or conveyed thereunder. Well, under the Securities Act, defendants to believe the plaintiffs have rights to enforce the notice holder or holder in due course. That same fraudulent notice of assignment is not in the pleading that was submitted and filed with the county for their application, for their order for foreclosure. So, under the pooling and servicing agreement and conveyance of mortgage loans, as defined by the pass-through trust account, the pooling and servicing agreement, Section 2.01, conveyance of mortgage loans, only the depositor was authorized to assign instruments in the trustee was no longer the holder or owner of the alleged debt obligation in question. The bank, as custodian for the trust, became the reputed holder, and the certificate holders became the reputed owner of the alleged debt obligation in question. in relationship to its cutoff date. So here is B, evidence of recording of indenture. If the indenture to be qualified is or is to be secured by the mortgage or pledge of property, the obligor upon the indenture securities shall furnish to the indenture trustee, 1, promptly after the execution and delivery of the indenture, an opinion of counsel, who may be of counsel for such obligor, either stating that in the opinion of such counsel, indenture has been properly recorded and filed so as to make effective the lien intended to be created thereby, and reciting the details of such action, or stating that in the opinion of such counsel, no such action is necessary to make the lien effective. And 2, at least annually after the execution, that's at least annually after the execution and delivery of the indenture, an opinion of counsel, either stating that in the opinion of such counsel, such action has been taken with respect to the recording, filing, re-recording, refiling of the indenture, as is necessary to maintain the lien of such indenture. And then we have, in clear violation of the above, as evidenced with the title search, there was no opinion of counsel, no recording, and there was no filing at the county land records of the alleged debt obligations. So, Chris, do you follow this?
Absolutely. This is killer.
This now brings up the unclean hands doctrine, does it not?
It certainly does, and it includes the
Here's what I have to say. Here's what the case says. Unclean hands doctrine. If said alleged debt obligation did exist and was presented to this court by the plaintiffs, then the unclean hands doctrine would be used as a defense, as the plaintiffs are guilty of deliberately withholding a fraudulent notice of assignment from this court to conceal their criminal involvement in its fraudulent creation and used to attempt to affect owner, holder, or holder in due course status for the purpose of collecting a debt they do not have the rights to.
Yep.
Plaintiff, which is the Dutch Bank National Trust, as trustee and trust for the benefit of the certificate holders, the pass-through account, which there's gazillions out there. All you got to do is punch up the bank that you're involved in, go to the SEC, and just put in the word pass-through account, and you'll be amazed at how many of these there are under each bank. National Trust Company have acted in a manner that is unlawful, oppressive, tainted with fraud, and absent of evidence of vital facts. The necessity of immediate relief to preserve assets, as set forth in these complaints, without the assistance of this court, the defendant will suffer immediate, irreparable, and substantial harm and injury as a result of the deliberate fraudulent actions of the plaintiff. Due to the above-mentioned facts, all entities concerned do not have and never had standing to bring action before this court nor the authority to invoke the jurisdiction of this court. Anyways, I rest my case. Chris?
Well, what I was going to say, this also implies that the county is in collusion because they know what the civil codes are. And by them not making it a mandate condition for the mortgage company, and since it's gone rampant, you can certainly name the county recorder's office as a joining party to a complaint.
Okay. Christopher, did you get back on?
Can you hear me?
No. Anybody hear him?
Can you hear me now? Anybody?
It's the same thing, but you're at about 20-25%. Maybe you could try to get back on. You might get a different router. Or, you know what sometimes works is if you reboot. Go ahead, Christian.
Another thing they have to do attorney on record as well.
Now, Chris?
Yeah, I'm here.
Okay, I got a question. Can I ask you a question?
Absolutely.
Okay. When we sign the loan docs, where is it that we give them power of attorney?
That is when you sign the deed of trust.
That gives them power of attorney?
Yep, because what you're doing is you're conveying all the property without no restrictions or reserve. You're giving the whole kit and caboodle, the whole house, sink and kitchen sink and everything else to them freely and openly under sound mind. Therefore, they become your landlord. You become the tenant, and you just signed everything off to them becoming your landlord.
Okay. Now, when we get a certificate of dishonor on the 9-210 validation of debt, then we revoke that signature and revoke that power of attorney. Correct?
That's correct.
Okay. And then it's at that point we issue notice and order, or just order?
Well, notice in some cases can be an order. You're not asking for permission. You're not trying to move them, you're not asking for their permission. When you give them notice, you've just done an act based off of you being trustee or grantor, depending on what the situations are. But you're setting forth the order of which they have to follow, and provided that you're not showing incompetency, a little bit what JC has mentioned and Eric has mentioned in the past, is as long as you show no inconsistencies or incompetency, you are the ruler of the roost. You're the one that sets the order forth that they have to follow.
Okay, so we're going to go up. Christian, are you back on?
Yeah, can you hear me?
Yeah, there you go.
We can hear you. We can hear you now, Christian.
Okay, I got a better connection, yeah.
Yeah, you're about 80%, maybe 90. Anyways, we were back at the point when you left us about the 2 records and the 2 files for the proof of the breach of trust.
Right, what case were you reading there, though? What was that case?
I have 4 cases. They all say the same thing. And I'll send those to you if you'd like. They're phenomenal. They are definitely the silver bullet, along with the fact that they cannot endorse it.
I'd like to have a copy of those myself.
Okay, Chris, no problem.
Yeah, I'm on Skype. I just fired Skype up.
Well, highlighted. They're pretty interesting. I pretty much read it into the thing for you, Christian, if you want to listen to the thing, but I can send it to you also in writing so you have a digital copy to work with for yourself.
Yes, I'm recording this call, by the way.
Okay. So, Christian, that case was a U.S. Bank National Association case on certificate account, and also a Wells Fargo Bank case as trustee for pass-through account. But these are cases against the banks being trustees, not upholding their fiduciary duty to the pass-through certificate holders because of lack of chain of assignment and lack of chain of title being able to use to claim the power of sale to even bring forth foreclosure enforcement.
Right. Did you do any discovery on that?
Huh?
Discovery for chain of assignment?
Yeah, I'm working on discovery right now ahead of time myself, and I should have that pretty locked in here within about 3 to 4 days. But under defenses, let's see, under 3-302, holder in due course, A, subject to subsection C, in section 3-106, paragraph D, holder in due course, means the holder of an instrument if, number 1, the the instrument when issued or negotiated to the holder does not bear such an apparent evidence of forgery or alteration, or is not otherwise so irregular or incomplete as to call into question its authenticity, and 2, the holder took the instrument, 1, for value, 2, in good faith, 3, without notice, blah, 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 and 4, without notice that any party has a defense or claim in recoupment described in Section 3-305A. And skipping down to C, except to the extent a transferor or predecessor in interest has rights as a holder in due course, a person does not acquire rights of a holder in due course of an instrument taken, 1, by legal process or by purchase in an execution, bankruptcy, creditor sale, or similar proceeding, 2, by purchase as part of a bulk transaction, not in ordinary course of business of the transferor, or 3, as the successor in interest of an estate or their organization.
Wow.
Claim UCC, you got to bring UCC under, claim the note is under UCC.
Oh my God.
So don't forget to claim the note under UCC. Can you hear me?
Yeah, you're loud and clear.
Hello.
Does everybody get static?
No, we're clear as a bell.
Can you hear?
Yeah, can you hear me?
Yeah, everybody's clear.
Okay.
Anyway, they're saying that under 3-309, the enforcement of lost, destroyed, or stolen instruments. A person in possession of an instrument is entitled to enforce the instrument if 1, the person was in possession of the instrument and entitled to enforce it when loss of possession occurred. Skipping down to B, a person seeking enforcement of an instrument under subsection A must prove the terms of the instrument and the person's right to enforce the instrument. And then they go over to section 3-305 in defenses and claims and recoupment, and stating that there's a lack of legal capacity. And moving down, that's paragraph 1, and under C and D states that an obligor is not obligated to pay the instrument if the person seeking enforcement of the instrument does not have the rights of a holder in due course, and the obligor proves that the instrument is lost or stolen instrument. And the reason why I brought this up, Christian, is because if we ask them to present the note, if we tell them that we want to pay the note and we ask them to present the note so that we can pay it, they're going to have a false instrument, correct?
Yeah, because you want to ask them to endorse it when they don't.
Right.
Let's say they do endorse it. Once they endorse it, then you're going to ask for the identification of the parties, which is.
And that's going to be
the chain of title.
The chain of assignment, the chain of title, which they don't have. That was my reason for reading all this, to prove your case about that they're not going to have the chain of title.
Right.
I have something I'd like.
Can we go back to where I'm lost?
Did you say you did a discovery on the chain of titles?
Yeah, I'm working on it right now. Are you familiar with Timothy Candler?
Well, let me read you what we write in there.
Okay.
Titles. In there, number 1, we want the unbroken chain of transfers and deliveries from the originator.
Unbroken chain of transfers and deliveries.
From the originator to the trust.
From originator to the trust.
Or current holder / assignee.
or current holder / assignee.
Showing ownership by the assignment.
Showing ownership
by the assignment.
By the assignment.
/ title page.
/ title page.
With an unbroken chain.
With an unbroken chain
of transfer from the delivery and acceptance.
From the
delivery and acceptance receipts.
And acceptance receipts. Okay?
Delivery of the delivery and acceptance receipts.
Wait a second. Of the delivery.
Of the delivery and acceptance receipts. Not just, they have to have accepted, they have to have a receipt that they've accepted.
They have to have a receipt that they've accepted.
Yeah. So it's of the delivery and acceptance receipt, or receipts.
So it's an unbroken chain transfer and delivery from originator to the trust or current holder
of the delivery and acceptance receipts. Of the delivery and acceptance receipts.
Okay.
To document the transfer.
Document the transfer.
To document the transfer and delivery of the bearer note.
And delivery of the bearer note.
Yeah, so it's of delivery and acceptance receipts to document the transfer and delivery of the bearer note, comma.
Delivery and acceptance and acceptance receipt of the bearer note.
Yeah, let me start over again. The unbroken chain of transfers and deliveries from the originator to the trust or current holder / assignee showing ownership by the assignment / title page with an unbroken chain of transfer of the delivery and acceptance receipt or receipts to document the transfer and delivery of the bearer note, comma.
Okay.
Now, from the originator to the sponsor.
From the originator to the sponsor.
Yeah, that's the first important one. Along with the delivery and acceptance receipt. Or receipt.
Along with delivery and acceptance receipts.
Right. With the bearer note.
With the bearer note.
Comma.
Oh,
let's read that again. From the originator to the sponsor, along with the delivery and acceptance receipts, with the bearer note, comma.
Okay.
Now, from the sponsor to the depositor.
From the sponsor to the depositor,
along with the delivery and acceptance receipts.
Along with the delivery and acceptance receipt,
comma, from the depositor to the trust.
From the depositor to the trust,
along with the chain of transfers,
along with the chain of transfers
and delivery and acceptance receipt
and acceptance receipt the originator to the trust,
and to the current holder / assignee,
and to the current holder / assignee,
period.
period.
Include the names of the document custodian,
of the document custodian,
and anyone associated with the document transfer,
and anyone associated with the document transfer,
for the trust, securitization / foreclosure.
I'm sorry, document transfer,
For the trust, securitization / foreclosure.
for the trust, securitization
/ foreclosure.
/ foreclosure.
That's killer.
Period. That's it.
Okay?
So the unbroken chain of transfers and deliveries from the originator to the trust or current holder / assignee, showing ownership by the assignment / title page with an unbroken chain of transfer of the delivery and acceptance receipt or receipts to document the transfer and delivery of the bearer note, comma, from the originator to the sponsor, along with the delivery and acceptance receipt or receipts with the bearer note, comma, from the sponsor to the depositor, along with the delivery and acceptance receipt or receipts, comma, from the depositor to the trust, along with the chain of transfers and deliveries and acceptance receipt or receipts, comma, from the originator to the trust and to the current holder / assignee, period. Include the name or names of the document custodian and anyone associated with the document transfer for the trust, securitization / foreclosure, period.
Okay? And this is, in what context do we utilize this?
That's what you want to do a discovery on, along with the other points, the original notes, the original mortgage, along with the allonges front and back, and you want the PSAs, and what else do you want?
The original notes, the allonges, the PFAs.
I don't have my discovery thing in front of me, but
Can we ask you about that on Tuesday? Or Monday?
well, I can pull it up here real quick.
Okay.
I have something I'd like to read too when everybody wants to hear. It's an 18 USC. Directly related to what we're talking about.
On a short note while we're waiting, here's a thing from Tim McCandless on California assignments must be recorded on September 24th, 2008. There, Christian?
Yeah, it's coming up.
Okay, most all foreclosures in California can be set aside. The power of sale by non-judicial means is contained in Civil Code 2932. In order to be valid, the assignment must be recorded, California Civil Code 2932.5. Most all notices of default recorded by the subprime lender have not recorded an assignment until just before or just after the trustee's sale. They rely on the MERS agency agreement to protect them, but under California law, they are wrong. Did you check that on yours, Chris?
Actually, that was one of my arsenals It's good that you discovered that.
Okay, I'm just trying to throw that in.
Yeah.
This is exactly what we're talking about here in the California state. These other guys are in Florida. One of those cases I read was a Florida case, by the way.
I'll be interested in that one.
Yeah, I'm going to send you that. You want me to send that? I sent you. I used to send you stuff, but I never got anything, so I didn't think you were a real person on email. But that's definitely a fiction guy there in email.
I fiction handle everything.
No problem.
I'm almost as bad as you, Christian. I'm still doing catch-up from 3 weeks ago, and I still haven't done the newsletter yet this week.
Okay, so we're under discovery. We have original notes, allonges, and PFAs, whatever they are.
And number one, the original lending signed promissory note without alteration signed by defendant with all allonges / attachments front and back.
Okay.
Number two is the original signed mortgage agreement instrument without alteration signed. Three is the notarized wedding signature, the assignment of mortgage without alteration with all allonges. Four is the pooling and servicing agreement. Five is the trust prospectus and prospectus supplement. And then six is that last one we just went over.
The PFA?
So six is the last one we went over before that long one.
Oh, okay, the last one. Okay, thank you, Christian. Anyway, when we got cut off when your phone wasn't working, we were talking about the you're talking about the two records. The two records and the two title as proof for the breach. And you were asking, what were you asking? We're asking here.
There's a lot of noise there. Did you mute on that speaking?
Huh?
Hey, Christian, can I read this this part about bank entries?
Yeah, go ahead.
Whoever makes a false entry in any book, report, or statement of such bank, company, branch, agency, or organization with the intent to injure or defraud such bank, company, branch, agency, or organization, or any other company by politics or corporate, or any individual person, or to deceive any officer of such bank, company, branch, agency, or organization, or the comptroller of the currency, or the Federal Deposit Insurance Corporation, or any agent or examiners appointed to examine the affairs of such bank, company, branch, agency, or organization, or the Board of Governors for the Federal Reserve System, or whoever with intent to defraud the United States or any agency thereof, or any financial institution referred to in this section, participates or shares in or receives directly or indirectly any monies, profits, property, or benefits through transaction, loans, commissions, contract, or any other act of any such financial institution shall be fined not more than $1 million or imprisoned not more than 30 years or both. And used in this section the terms national bank, you don't need to hear that part, but it drops down into bonds and obligations of lending institutions. Whoever falsely makes, forged, counterfeits, or alters any notes, bonds, debentures, coupons, obligation, instruments, or writings in imitation or purporting to be in limitations of note, bonds, debentures, coupons, obligations, instruments, or writing issued by the Reconstitution Financial Corporation, Federal Deposit Insurance Corporation, National Credit Union Administration, Homeowners Loans Corporations, Farm Credit Administration, Department of Housing or Urban Development, or any land bank, intermediate credit bank, insured credit union, bank for cooperative, or any lending, mortgage, insurance, credit and saving and loan corporations or associations authorized or acting under laws of the United States shall be fined under this title or imprisoned not more than 10 years or both. I mean, this is some serious crime that these people are conducting.
Yeah, like I read in the Banker's Handbook there, under the special consumer credit rules and things, were the FTC and Consumer Credit Protection Act. There's criminal penalties there.
I think that's what Jacob should really be including, is these statutes that are just like, these are vicious. This is like a mean bulldog.
Which ones, Chris?
That's 18 USC at 1005. That's 1005, bank entries and reports and transaction. And the other one I've got here is 18 USC at 493, bonds and obligations of certain lending agency. Number 3 here would be 18 USC at 514, fictitious obligations. You've got 18 USC at 657, lending credit and insurance institution. Fraud and swindles, that's 1341. You got definitions of scheme or artifice to defraud, that's 1346. These are all the key ones against these financial institutions doing things that we've been talking about all evening.
But do you have cases that go along with these to show how to utilize them?
Oh, I'm sure there's a billion cases.
You know, probable cause complaint.
Yep, there you go. Or you can do unclean hands. You know, either way, or RICO and racketeering. That's what I'm about ready to put together, is my RICO and racketeering complaint. You can damn well bet these are going in it.
Christian?
Yeah.
When we got cut off, you had asked me 2 questions. And one question was, did I have proof that they didn't make the payment?
Right.
And this is going to be, based on I was also going to, you asked if I had proof that I asked them to pay with the special deposit. And so I need to give them an order to make the trust deposit, and then we got cut off.
Yeah, then you need an order to do the conversion and make pay the bill.
Yeah.
Then give them a time limit. When they don't do that and respond, well, then they fall into a breach.
Right.
Certify that the breach was, done. Then you come forward with a cause of action and with a court action.
But that's in addition to the 9-210?
Yeah, that doesn't include the 9-210. That's just the 210 is just for to give you the authority to pull the contract. Nobody to
okay.
You
mean the right of signature and the power of attorney?
Gives me the right of rescission, right?
Right of rescission.
Pull away the power of attorney and invalidate the whole contract, the security agreement, and everything from there. Because it invalidates this. Then you can come in with look on the evidence created for the breach or the breach of trust.
Now, if you're in the see, I have this thing I'm working on right now where I've gotten in with the head of the loss mitigation department of the bank, and I was able, here I'm working on a loan modification, and I get them to the point of putting the contract together, and now I've asked them to validate the debt so that I can move forward with the loan modification to make sure that they're the ones that are having the debt, that they're holding the debt.
Mm-hmm.
Have you heard of anybody doing that?
Well, are they the actual lenders?
Yeah. Oh, the original lenders? No.
Well, how are they going to validate the debt then? It's not their debt.
Well, if they had the proper paperwork, the chain of assignment, doesn't all that paperwork have to come along with it?
All right. So you're saying they have the paper now.
I actually called up the original lender to ask for a copy of all my records and the chain of assignment very nicely. Told them it was for the IRS and on a tax thing. And they're pulling it together, and I actually got the CFO on the phone to help me. So we'll see how far that gets. They had two departments, and one department pulls up the original records, and the other department pulls up the sales to the bank, which was actually 1 week later after the closing of escrow, I find out.
What'd they do?
I called up the original lender, when I'm putting the UCC1 together to make sure I have the correct address to put down. And so in the interim, I asked them for a copy of all the records. I told them there was a fire, and I lost all my records, and I'm pulling my records together for the IRS, and that could you help me get all those records together? And then they switched me to a second department, which says, we sold that loan a week after, the escrow closed. And I said, well, that's fine. Can you give me all that paperwork that shows me that you sold that to that party with...
Mm-hmm.
What did they say then?
Oh, they're working on it. I got the CFO to get the documentation department. He gave me a heads up. The CFO said that I could tell them that he told them to do it.
All right.
So I'm hoping within the next 3 days. I asked them to do it within 72 hours. If they need to give me a copy of my paperwork, if in 72 hours they don't do it, I was going to issue some kind of a order or notice that they failed to respond in 72 hours.
How are you going to prove that you asked them?
I already did full-on emails and delivery by internet to all parties.
Okay.
3 departments, 3 parties, including the CFO. And I figured out their email addresses.
Well, as long as you got some kind of proof that you asked them, and then when they don't, then you can certify it.
Yeah, I have proof. Got to create the records, right?
Yeah, that's done with somebody who's an independent party, at arm's length, clean hands.
Okay. Can a notary certify an email that was sent?
Sure can.
They could, and then they could do a certification that there was no response in 72 hours?
If you don't want to do that, he doesn't want to do that, well then ask him if he'll certify your affidavit that you sent it.
Okay.
So he could do a certification under his hand and seal that by your affidavit you're swearing that he's doing a certification based on what you swore.
Okay. And she'll do that.
the notary record is outside the hearsay rule exception to the rules of evidence, Rule 902 under federal.
Say that again, please. The
notary record, the certification that he makes up under his hand and seal, is outside the hearsay exception rule under Rule 902 in federal.
902.
It's a public document. Any notary certification is a public document. Automatically gets outside the hearsay rule exception.
Okay. Now, Christian, on the NOI and the SOI, I'm trying to get it straight in my brain because I'm at the 12th hour, and I'm doing a UCC1. I'm putting the chain of assignments of the banks in there. I called the Secretary of State, and they said you can put as many people in there as you want for the same cost as a UCC1. So I was going to put, since I have the chain, and there's 4 banks. I have the original bank number 1, and then I have the last bank number 2, so that I can have public notice to all 4. And then I would just have the UCC 3, and so when I put down on a UCC1 under where is it here? Under there it is. On the UCC1, I've got the original mortgage that the title company gave the promissory note to. And then
Muted. Unmuted.
Well,
Muted.
Let's press star 6 on mute.
can you hear me?
Yeah, go ahead.
Okay. So I have under box number 1, I have the original bank that's on the mortgage deed of trust that the title company gave the promissory note to. And then I have the bank listed that they sold the note to. So in this case, I have 2 banks. And then I have the homeowner as the grantor under the secured party with box 8 with the nomenclature changed to trustee and grantor. And I have a little box with an X checking that box. And then I have a non-filing UCC box checked under number 5 for alternative designation. I called up the Secretary of State and I asked them about that box. They said they've never had anybody use that box.
You wonder why?
I said, could you tell me what that's for? And they said, we really can't. We've never used that box. I said, could you get your supervisor to tell me what that box is for? Yeah, I asked him. We don't know what that box is for. Anyways, I have under number 4, this is actual constructed public notice by grantor as owner and holder of all rights, title, and interest with the non-negotiable instrument claim by number RA 1 through 9 US with all the attachments and proceeds therefrom as being held in the private. If any information is needed, contact the grantor at the address below. And I have it signed by grantor, and then I have the address. Right? Do I need to sign it?
On that form?
Yeah.
I gotta sign it and get it to him. That's the thing.
Huh?
I don't think you have to really sign that. I was worried about when I get back a certified copy, then if I was going to do something that I might want to sign the certified copy. This is just a notice.
Okay, so I don't need to say by grantor then.
I don't see how you could sign it and give it to them and get it recorded as your signature.
They let you upload a picture of your signature and have it as an attachment. That's how. with those people electronically. It's just one document. And I don't know, how that's how they handle it. And you don't give them the document. You have to input all this information into the record so that's digitally searchable, and then they create the actual document. You don't do it. And so any attachment that you have with a signature or under 4, I guess.
Washington?
It's in California.
California? All right.
Mm-hmm. And so I've got it. So is that correct then? I've got it. In box number 1, I have the original bank. Box number 2, I have the bank that they sold it to a week later. And then under the box number 3, the secured party with the nomenclature changed to grantor, I have the homeowner name. And then I have the financing statement covers the following collateral, and I have the constructive public notice in there with the address. And then on number 3,
did you check the non-UCC filing bond?
Yes, I did. And I also, under option 8, put a little box with a check and put trustee/grantor, and in parentheses I put nomenclature change. And I asked her if that was okay, and she said that's fine.
Right.
So then I go to the UCC1, and now under assignment I'm going to check full. I'm going to put the current record information, which is going to be the same on UCC1, which will be the 2 banks, the original and the one that supposedly they the loan to. And then I'll have Amendment 8, which I'll change the claim by to transfer by. And then I'll have optional 10, trustee grantor, nomenclature change, and I think that's it.
Yep.
And then I filed the UCC1 with the state. It takes them about an hour electronically, and then they'll allow you to pull it up, and they charge you for a search, like $5, and then they charge you $5 to certify it. So it's $5 to file, $5 to. And in 1 hour, they assign it to a briefcase, and in 5, then you can search for it. In an hour, it should be ready, and they charge you $5 for the search, and then they charge you $5 to give you a certified copy, and that takes about 2 hours. Now, then I would do the UCC3 as step 2, and I would file that, and then get a certified copy. So now I have a UCC1 filed with the state, and I have a certification, and I have a UCC3 filed with the state, and I have a certification. And now I want to go the next day on Tuesday, and I want to record a notice with the county.
Right.
And I did a really incredible study today, and I don't want to get into it right now, but it's basically on the origin of thought, and it's in the origin of thought of the area of signature, and it has to do with titles and signatures and seal. And I want to finish it up before I talk about it, but it's really pretty remarkable how I was thinking of it in context of of using in the future of using a seal instead of a signature, but in context of this context here for this instant, it's more like when we use the word notice, and I'm talking about making a record of a notice in the county,
Still there? Hello?
Sounds like you got kicked off.
Yeah, sounds like he dropped off, yeah.
They'll only accept a notice?
Okay, he dropped out there. We
Lost you.
Yeah, the county, now I have my 1 and 3, and I'm going to record a notice in the county, I'm going to have a notice of record.
I just put a title on it. It's just notice.
That's it, just notice?
Notice. County's got to record notices and affidavits. If it's titled notice or titled affidavit of something, they got to record it. We lost you again?
Yeah. Is that me that I'm getting lost, or that's the call, or what?
Yeah, you're like muting out or something, somehow.
Oh, okay. Anyways, I just titled the document notice, and that's it?
Yeah.
And then what do I put in the notice? What kind of language?
The same thing you got in collateral block 4.
Okay.
But that's where you put that RA number, isn't it? Yeah, it's got the RA number in there. Yeah. Yeah. But that's all he's filing with the county is the RA number, isn't it? So read it again.
Okay, read it again. This is actual constructive public notice by grantor as owner and holder of all rights, title, and interest with the non-negotiable instrument claimed by number RA blank US, comma, with all the attachments and proceeds therefrom as held in the private. If any information is needed, contact the grantor at the address below. Now, Christian, did you pick the word, if any information is gleaned, as being more trust-orientated as opposed to the word needed?
No, I just picked that word. But I might change something in there. I might change negotiable instrument to special deposit.
Might or should?
I think I probably would.
Okay. And I love the word choice gleaned, but I thought people are so whatever. Yeah, can you hear?
Yeah, I hear you.
Okay, so we've got the notice, and it's just going to be titled notice. We're going to have the title block 4 in there. And on UCC1, I have non-negotiable instrument. I'm going to change that to special deposit, and it will also be then there on the notice that I'm giving to the county, special deposit as opposed to non-negotiable instrument. Is that correct?
Right. Uh-huh.
Okay. So that's going to be my notice of my claim, and I have to do the same thing as a notice of a transfer, right?
Right. Same wording except the transfer wording is a little bit transfer instead.
So now my records are a public notice, a UCC, a non-UCC filing public notice to the state, and now a notice to the county, correct?
Right, notice in the county of that UCC3 nomenclature, same thing as in that collateral block 4 in the county.
Okay. And so
the actual form itself, not the UCC1, not the UCC3, just completely different document you're making up yourself with just the title of a notice on it.
Okay, I got it. But now those are my 2 sets of records now, my 1s and 3s, and I have 2 of each. I have one from the state and one from the county on the claim, and one from the state and one from the county on the transfer.
Now you got 2 records in claiming. You got a UCC1 and a county notice. You got 2 records on the transfer. You got a UCC3 and a notice into the county.
Right. Okay.
Records, 4 titles.
What's that with titles?
Yeah, records are titles.
Oh, records are titles, correct.
Titles.
Okay.
I can claim
now
these titles.
Okay. Okay. Now that I have that in hand, pretending they have the note to pay.
I've got to come up with beneficiary and trustee.
Huh?
Let's set them up as beneficiary and trustee.
The phone cut out.
You have to set them up as beneficiary and trustee. Now, they're already set up as beneficiary. So now I got to set them up as trustee.
Okay, so now I'm going to have a revocation of the current trustee, and I'm going to have an order to reappoint a new trustee. Does that sound? I'm going to revoke the power of attorney because I've got my certificate of dishonor for the 9-210. I'm going to revoke the power of attorney. I'm going to have a rescission of the signatures, rescission of the contract, and signatures. Do you hear me? Am I lost?
Contract and signatures, right, revocable.
Okay, so the contract and signatures and a revocation of the power of attorney. Now I have the wherewithal to issue an order to reappoint a new trustee, and I'm going to appoint the original beneficiary, or I'm going to appoint the one that's pretending to be the holder of due course that's coming at me with the foreclosure.
Well, the first bank is the one you want to deal with that's beneficiary. You want to close it down there. That's the root. Everything else is just beliefs, and it dies when you pull the root out.
So I want to take the original trustee that my signature on the trustee gave him the power to appoint their trustee. So I want to pull the root out by giving them an order that I'm going to reappoint as the trustee the bank that's coming at me in the original bank that's in the original mortgage.
I hereby appoint so-and-so bank trustee for whatever the security number is, the security agreement, whatever number they're using, whatever the account number is.
Which is the loan number that they originated, and it's still the loan number on the trustee sale.
Right.
Okay. Then, at the same time, I'm going to do a UCC1 on the grant deed. The title company transferred the mortgage deed of trust to the county at the time of closing. They sent me a receipt in the form of a grant deed to say a thank you receipt. I want to put the grant deed on a UCC1 and claim that, and then I want to transfer it back to the county. To close down the county that the new trustee over at the non-holder due course new bank that's coming at me by they appointed a trustee to bring a foreclosure action against me based on the title of the address in that mortgage deed of trust that the county's holding.
Right.
Okay? So I'm going to do a UCC1 on the grant deed. And what does is it the same kind of notice, constructive public notice for the grant deed? Is the promissory note?
Yeah, you're taking the title, which is the warranty deed, which is the debt title, and you're going to turn it into an asset title and give it back to them in merger.
Mm-hmm. That's correct. And debt title, excuse me. And the grant deed is the asset title.
Yeah, I want to give them an asset title to terminate.
Okay. I think I can understand. Do I use the same kind of thing where, in this case, when I say rights, title, and interest I'll put in the word grant deed instead of special deposit?
No, you're making a special deposit again.
Yeah. That's right. Sorry. Another special deposit. Okay, now, the trust I'm going to need the trust receipt as a record, am I not?
Yeah, it's the title to the debt title that you're going to merge with the asset and give it back to them.
Well, the trust receipt is the special deposit, isn't it?
Trust receipt is special deposit, right?
Okay.
Trust deed is when you return it back to them with the proper endorsements on it, turn it into an asset title. It's going to be merged with the debt title.
So I'm going to have to endorse the grant deed, right?
Yeah.
And I'm going to add the special deposit, and I'm going to have to endorse the promissory note back to the bank as a special deposit when I order them to pay it.
Turn it into a bearer title so that when they're holding it, it pays.
Okay. Turn both of them into bearer titles.
Now, the one in the mortgage is a little bit different than the county because you don't have that title. It's really been all paid. You just need to create the records that it's already been done. Well, in the county, it hasn't been paid yet.
Oh, okay. So
The county is just putting your debts that are obligations against that title first in order to terminate the trust. So you got to put some kind of payment instrument. That's your special deposit. This is just the asset title merged with the debt title, which terminates the trust.
All right, but how would my order read for the county?
Which order? Which order?
Not order. I mean, when I return the grant deed as a special deposit, as I endorse it.
Same notice, claiming and transfer. Just like you did on the mortgage.
Yeah. Okay. And then after I've created the records and I have proof of the trust, then I can give them an order to merge.
Well, when you do the three, you've already sent it to them. That's just a notice that it's already been merged.
And so I give a notice to the trustee for closing on that.
But now, when the titles have been merged, the trust terminates.
Yeah, but I have to make the trustee aware of that because they're not going to check.
Do you got to instruct them to disperse the funds there?
Say again?
Is that where you instruct them to disperse the funds? Because that's what you said when you merge the titles and you terminate the trust. Then that's
well, I might want an instruction to that the titles have been merged. Here's a record of it. Now terminate the trust.
Okay, hold on. Counties titles have been merged?
Here's the records that the titles have been merged. Now terminate the trust.
Okay. And that just goes to the county recorder?
Yeah.
To the trustee?
Well, you may have to send it to the, who's the guy? County assessors.
Well, county assessors?
Yeah, the head guy there that does the, I forget his title.
that takes care of the county trust.
Now, I'm going to send an order with an order to the original bank on the trust deed with an order, and I'm going to have a copy of the promissory note that's endorsed, and I'm going to send that to the original lender.
Do you need an order or just a notification?
Need an order. You need an order, Christian?
Well, it could be that all they have to have is maybe just a notice there because you're just noticing them that it's already been done. Unless you're going to order them to do something. What are you going to order them to do?
Read the notice.
Okay, so I'm going to have a notice that declares.
Yeah,
I'm going to have
notification.
a notice that declares that the special deposit has already paid.
That's just a notice, that is.
And what do I know?
You want the proceeds back from the termination of the trust, then order them to distribute the overage or the remainder on the trust of all the proceeds that are attached therefore on the note.
Wow.
Do I want to do that, Christian?
Yeah, that's up to you. What do you
Why
need
not?
that for?
Question is, why not?
Well, I'm not trying to assume anything. That's why I'm asking. Sorry.
But you're supposed to treat it like it's a done deal.
C8-507.
Which one is it?
UCC 8-507.
8-507. Okay. And so I'm going to order the proceeds from the note back. Do I have to specify how I want them back?
Yeah, you could.
I mean, I want a,
by check form.
huh?
And the remittance by check form.
Okay.
Payable to the beneficiary.
Am I now the beneficiary?
Who do you think's running the show here? The beneficiary always gets the disbursement and payments.
No, I know that. That's why I said I'm now the beneficiary.
Actually, I thought,
Where did I claim that I'm the I didn't declare, notice, or claim that I was the beneficiary. I've always been the grantor.
Oh, you might want to make yourself known as beneficiary before then.
When?
did she? So I thought
When
there
do I
was
make
like,
this beneficiary? In the timeline.
At the beginning of the indenture when you form the trust.
is this some kind of new trust? I thought the idea was when you combine or terminate, merge the trust that and disperse the funds, that it's supposed to, the note goes to the bank beneficiary to pay for it and basically zero the account. How did he become the beneficiary?
Yeah, the bank was beneficiary on the note, but I'm beneficiary, say, on the proceeds therefrom.
So at some point, the bank stops being the beneficiary and you become the beneficiary?
Beneficiary.
The bank as beneficiary has been taken care of by the merging the titles with the note.
And that ceases then, right? At that point?
Yeah. They're done.
Okay. Okay, wow. Okay. I'm barely keeping up here.
Okay, so once you give them the notice then you can make yourself the beneficiary for the proceeds?
You can step in as a grantor.
I would want to decide this before I actually, which way I want to go prior to doing all this, because it all has to be thought through from start to finish, and then you put it into action.
Right.
Because if you put it into action and you change your game plan, you're going to get messed up.
Right.
But we got to think it all through before we do it and have all the steps put in line, because, after we put it into action, it's too late to change the game plan.
Absolutely. So I've given them a notice that the records indicate that the trust deposit has been transferred to them for payment. And this will be this is hard for me to understand, but it was actually transferred to them as special deposit on the day of the closing of the escrow. I'm just now
noticing
huh?
I'm just now noticing that.
Now noticing that, okay? I'm now noticing that, okay? And then I'm going to put in there that the merging of these two titles of the asset and debt titles now terminates the trust. Therefore, I'm going to now I make an order to take all the proceeds from the note in remittance and check form payable to the beneficiary, and I name myself as the beneficiary for that payment.
Yeah, the remainder beneficiary or the income beneficiary or something like that.
Okay, income beneficiary. Okay.
So it's understood that it is going towards payment of the bank as beneficiary. You're talking about overage, is that correct?
Yeah, the remainder. The remainder goes to the beneficiary, the income beneficiary, or the remainder beneficiary.
Remainder beneficiary.
The bank's the first beneficiary, and the disbursement pays the bank, and then the overage, you at that point become, because you're a pre-decision, become the beneficiary at that point, and then you get overage. I think what Chris is saying.
Now, there's two beneficiaries. There's an income beneficiary, and then there's like the remainder beneficiaries. It depends how you want to call it, but there can be two classes of beneficiary.
Okay, can I be both?
No, the bank's the first beneficiary.
No, the bank's already out of the picture.
Well, then what's overage is then you can make yourself the beneficiary after that. That's the two he was talking about. Was the bank and you, then you.
Oh, the bank is the beneficiary?
But you just got to understand, the way I understand it, correct me if I'm wrong, because I only understand it from what Chris was saying in principle, but as soon, the whole point of merging and terminating, Christian always said that's causes the disbursement of the funds. The disbursement of the funds is to stop the trust and take the note, pay the bank as the beneficiary. Christian's just saying if there's anything left over, you become the beneficiary, and you're just, it's a roundabout way of just notifying them it's already a done deal, but by the way, if there's anything left over, I'll be the beneficiary and take some overage. That's what you're saying, right?
Yeah, but this beneficiary was also created at the same time the first beneficiary was created. So you would have to know that part out. So there would be like a main beneficiary and then a remainder beneficiary, or say an income beneficiary and a remainder beneficiary, or whatever you want to designate it. But then the main
what are the two responsibilities of the income versus the remainder beneficiary? The remainder beneficiary is for the proceeds left over from the note that need to be dispersed to a party, and what is the income beneficiary?
Yeah, it's just like in Gilbert's where it says, the beneficiary upon termination of the trust, he gets the proceeds of the income, let's say, but then the principal gets distributed to his heirs. So his heirs could be this remainder beneficiary, and that's you. I have to set myself up in the original indenture, setting up the two beneficiaries so that when the one main beneficiary is taken care of, then the remainder gets dispersed to the remainder beneficiary.
So, isn't it understood right at the beginning, the bank's the beneficiary right from the get-go? That's already created before you got there, right?
Yeah, you have to do that before. You have to have that intent and purpose set up first.
Isn't it already established? The bank's already the beneficiary? Because you're coming here after the fact, aren't you?
Right, you're telling them they are, you've already set them up as beneficiaries with payee on the note.
Are they the income beneficiary?
If you want to call them income beneficiary, and then the remainder beneficiary gets paid the rest of the proceeds.
Okay. Now, the question is, the proceeds, what about all the payments that were made to the trust, for the, the monthly payments? Is that what we're talking about, the proceeds, or we're talking about the derivatives from the bonds and the monetizing? Or both?
Well, those all could be special deposits also.
What can be special deposits?
All those payments.
Okay, so the payments could be special deposits, and you're going to ask for that special deposit back?
Yeah.
And the bond that they didn't tell you about, that's out there, Cyberland, what about the interest and the insurance monies for that?
Yes.
That's another special deposit?
No, that would generate off all those special deposits.
Okay.
So in other words, you have to put all this stuff down.
Yeah.
Yeah, when you're asking for the proceeds are from the special deposit of the payments and the bonds that were generated, the income generated off the bond from the
bonds, the interest, whatever.
But that's the promissory note that's the special deposit, right, Christian?
Yeah, along with the payments that you made.
And that's the same special deposit as the promissory note?
No, they're separate.
Yeah, that's okay. Where did I claim that special deposit?
I don't know. When did you?
That's what I'm trying to figure out. What happened to me at my incompetent level?
Claim them then. You haven't claimed them.
So I've got to claim the payments.
Claim them and transfer it to them. Get all your check numbers and put them down. Claim them. Transfer them to them. Now you made a special deposit. Then ask for it all back. All the derivatives, all the bonds, the proceeds, the interest therefrom.
Now the bond, if I can get the pass through certificate number, I can claim that as well.
I don't need to know what it generated, although I can check it. All that stuff is generated off my signature. All I have to do is claim what I put my signature on. Claim what my signature went on and all the proceeds therefrom. Claim it.
Okay.
But you remember, you got to claim that you're a beneficiary too from the very beginning, because earlier Christian said that the bank is the beneficiary, and then you move them to be trustee, because that's how you cancel out the trust and disperse the payment.
Okay, let's go over that, please, Michael.
That makes sense.
Let's go over that, please. When we revoke the power of attorney, and
when you move the titles, you're claiming that you're a grantor beneficiary, and you put in there benefit of first fund or excess fund.
Jacob, are you seeing the bank as the beneficiary right from the get-go? That was set up.
I now see that there's two beneficiaries, because obviously you've been making a special deposit of the payments.
Well, no, it's a dynamic thing. I mean, I'm just looking at this on the theory of the way I got it, but it's a dynamic thing. I think that other guy, David, said it. He said, look, when you are doing the merging and the terminating, that's you're basically assigning the bank, or you're telling as a grantor, you're telling the bank they're going to be the trustee now, because when they're the trustee and beneficiary, that's what's causing the collapse. So if they're becoming the trustee, now the beneficiary position gets freed up, and that's what you put on yourself. Does that make sense? Is that right?
Yeah, because that beneficiary existed from the beginning, both of them. You can have multiple beneficiaries.
But
we have the income beneficiary. From the beginning, we have the income beneficiary, and we have the remittance, or whatever you want to call it. Remainder, or whatever. We have the remainder beneficiary, that's us, and we have the income beneficiary, that's the bank.
Yeah.
Okay. So now when we get a debt validation back, and we revoke the power of attorney of the trustee that the bank has got in there, and the original trustee had in there with the original bank, they both get removed, right?
Right.
That's two separate trusts, basically. And the county is a separate trust. We're already operating with three trusts.
Right.
Okay, so once we revoke the power of attorney, we're from the VOD, the validation of debt, we're revoking the original trustee, and in my case, the original beneficiary in my case, unbelievably, is MERS. If you guys can believe that one.
You're getting rid of all the debtor-creditor contracts because they're fake or fraud. So you're rescinding the signature on them. So they don't exist anymore. And now you're creating all these records for trust, and all your trust records stand, and there is no debtor-creditor records.
Okay. So I want to go back over what was the gentleman's name that mentioned about the trustee?
That's Michael.
No, the other guy.
Sure. Me?
What's your name? Yeah, what's your name? The one talking about the trustee, not Michael, the other gentleman?
I guess it'd be me, Shane.
Oh, Shane. Yeah, Shane. Okay, Shane. When we revoke the power of attorney based on the violation of the UCC 9-210, and we rescind when we have a rescission of the signatures and the contract. Now there's no trustee, right, Christian?
Right.
So now we have to reappoint a trustee.
That's what UCC3 is about. You're moving titles. You're claiming that you're a grantor beneficiary, and then you're also claiming that the bank or whoever's holding the mortgage is beneficiary trustee.
Okay. So now we have reappointed the trustee on the UCC3 to the beneficiary/trustee bank.
By assignment. So that's your transfer assignment, right? The formation of the trust?
Right.
That's your transfer of assignment. Do we have to register transfer?
It's just a notice that the trust was formed back in, 2004?
Yes.
The trust actually formed in 2004.
Correct.
The time the note went into the hands, that's when it was.
The time that the special deposit promissory note went into the hands of the beneficiary.
So the wording of the assignment, which is one of the forms of transfer, has to be such that it's just making it known that this is recognition of this event happened in the past. So it's just a recognition of something that's already been.
Yes, a public
notice.
Okay.
It's a deja vu.
Simple as that. Wow.
Now, once the bank gets notice that they are the trustee, there's a beneficiary, that the special deposit transferred to them on the date of closing of escrow, and that trust terminates, and we now are the grantor remittance beneficiary. Don't we need a trust for that? A trustee?
For what now, Jim?
when we give them notice that the special deposit was given to them on the day of closing, that we have records of the trust, and that they're to be merged, those two titles, and that trust is now terminated, and we also, on a separate order the proceeds of the remainder of disbursement of funds to go to the remainder beneficiary, which is what we claimed that we were also on the day of closing at the origination of the trust. Then when the income beneficiary trust is terminated, now don't we need a trustee for the remainder beneficiary?
Isn't it done?
If you have a trustee, you have a trust. You don't need a trustee.
So the trust is gone. Yeah, you just.
No, but I thought there's I thought there's also another trust. The beneficiary, us as the grantor, we're going to be the remainder beneficiary also.
So that's
If we terminate.
Wait. In order for the trustee to be not in breach, he must wind up the trust and disperse the funds.
So he's the remainder beneficiary also. The bank.
Yes.
Okay. We never went over that. I just trying to make sure.
Yeah, the bank gets paid off, and what's ever left over goes to you. And
So
that's what the trustee is supposed to do. That's what you appointed the bank to do. Instead of them getting the whole kit and caboodle, you're telling them you want the money back to you.
When we give them a list of the payments of all the checks that were paid, all the check numbers, and we ask them for that disbursement of funds to be paid to the remainder beneficiary in the form of a check.
Right. Well, along with the interest and all the proceeds and the derivatives and the bonds that were generated from that.
You think they'll give that all to you, or will that be negotiated?
They don't. Check out 8-507.
Which one?
8-507.
They have
8-507?
Entitlement order.
Entitlement order.
Yeah, they have to give the funds back to you. Otherwise, they're in breach of trust and coercion and everything else. And we already gone over that the other night of what we could do to them.
Anybody have a UCC-507?
No, I haven't got my book yet. But basically, and then what Jacob's getting at is the trust is over. Once the last play is made out, and let's say you get that, then it's all done, right? As soon as
Wait, no, it's not all done yet.
Well, hold on. I just mean as far as the trust is concerned, because you're talking
No. We've got the most important thing.
Well, let me ask Christian though. So,
Christian, don't we order back the special deposit promissory note to us?
no. That was supposed to be to pay the. I thought that was to go to the promissory note.
It pays the house. The promissory note pays the house.
Well, the promissory note paid the house?
Yeah.
And how did it do that?
What's your not proof?
The reconveyance of the deed is the proof?
That was the whole merging and making them the trustee is going back to that model. You got to go back to that model that Christian talked about with the circle and the upside down T. Is that right, Christian?
Hold on a second. Hold on. I want to actually get the house back. How am I going to have proof I got the house back? The reconveyance of the deed?
Well, you got the deed, don't you? It's just cloudy title with a security agreement cloud on it.
Okay, so I have to have the cloud removed.
No, the cloud will be removed once you merge the title.
Okay.
It's going to give you a release of lien.
I think you should go back and just explain the basic model where, like you used to do with that circle and the T and the private.
No, it doesn't do any good. Hold on a second. The cloud is removed when we merge the titles.
Right.
We've terminated the trust down at the county.
They give it right back to you, and then they disperse the funds into your pocket. Because you order it. You remember, you're the king. You gave them the order.
According to that model that Christian had, the whole problem is the note basically goes into a special deposit or trust, and it gets never heard of again. And we end up paying the mortgage. They're mutually exclusive things. So when you break that, because you were supposed to, he said, according to that thing, he said, you were supposed to go in there, express the trust, and tell them to take that note and pay the thing, because you're not supposed to be paying the mortgage. That was like a backup insurance policy. So what we're doing is we're getting there, expressing it, doing the termination and merging, and finally getting a hold of that note. So basically that's why all the money comes back, because that's really, the note pays for it completely, so therefore all that money paid is owing back. Is that right, Christian?
Yeah, you're exchanging the house for the note, but then you get all the proceeds that were generated from all the interest and all the payments that you made. You get all that back.
Because they're two separate things.
But but the note, Christian, what happens to the note?
The note goes to pay the house.
No, but they keep the note is in Wall Street.
Oh,
no, well, they've already been paid. They've already been paid. They've already been paid.
But they still have the note in play. It's going to continue to generate interest.
But that's their problem.
Yeah, interest, which is yours.
Yeah. So when you ask them for the remainder and the note's still in play, you continually to get payments from the interest of the note when it's in a mortgage-backed security pool.
Well, you terminated the note. After that, there is no more note. It can't be generating any more funds.
Oh, they're going to leave it in play. They've got huge contracts. They've got contracts that they've signed to assure that they have standing and that they own the note, and when they really didn't, and it's out there.
Hey, debit credit, when there's any controversy under common law or an equity, what's going to prevail?
Equity.
Equity.
So we just forget about everything after that?
Yeah, it's up to the other party to start coming back to them because something screwed up. It's not your fault.
Obviously in about 5 or 10 years from now, they're going to start straightening out who's actually got the notes, and those parties are going to come back after people.
But not after you, because you terminated it.
Okay. So now I can sell the house if I want and have no controversy?
Yeah, as long as you got the title cloud removed.
Actually, does that make it like an allodium?
Yeah, it should.
Christian, if somebody foreclosed on a house, there's obviously, if someone foreclosed on a house, then doesn't that leave a cloud on the title?
Yes.
So if I have a friend that's got a house that got foreclosed on.
Foreclosing. If it's been foreclosed, there's no cloud on the title.
No, it's foreclosed.
It's foreclosed, a cloud on the title. Somebody else owns it. If they're foreclosing, there's a cloud on the title.
Okay. But if it's foreclosed on, there's no way to get it back?
Well, unless your right of redemption is going out so in a year in advance or depending on your state laws. But for fraud...
Oh, a redemption period, you mean?
Yeah, redemption period, yeah. But for fraud, you can vitiate the whole thing. And you can't pretend it. So you'll be cut off from probably getting the house if it's been sold and foreclosed, because if you didn't give notice prior to, you're cut off.
What kind of notice?
Notice that you got some kind of adverse claim. Breach of trust, say. That give notice. Anybody in the case, without notice, clear.
We got too many people. We got too many people talking. We got too many people talking. Let CW talk, and then also let Jacob talk. Okay.
in this case, the guy did give notice a week before before the sale.
To who?
To the county.
To all parties? To all parties?
He gave notice to the county.
Hey, good enough. Bank didn't have notice. Who else didn't have notice? They'll take free and clear.
So the fraud would be that he didn't have the power of sale to initiate the foreclosure proceeding in the beginning.
Operational law.
Operation of law.
They did have power.
Huh?
You're agreeing to the sale.
I'm sorry, I couldn't hear you. Operation
power. They're giving you an administrative remedy or administrative default that you're agreeing to the sale. And they're going to sell the house by operational law without any notices.
Well, what if you notified him? Because, like, in my sister's point, okay, I know that's when I was in the credit debtor thing, but I basically sent it to B of a bond, to pay it off, and I notified the auctioneer that this was a fraudulent sale if he sells it, and then he could be liable for it. And then I also notified the court, and the court ignored it, and they didn't respond to any of my stuff, even though I sent it notary. Presentment.
You sent it to the court?
I sent it to
the court on notice?
I put the judge on notice. That signed it, that okayed it.
You notice the court shouldn't have sold the property free and clear because now you gave notice. Now the bona fide purchaser can't be a bona fide purchaser because you gave notice.
They came back and told me that I wasn't a party to the action, but I told them that I was, and I notified the judge, and I never got a response back.
Okay, where was your proof of that? Did you put in an NOI? Did you follow it up with the SOIs? Otherwise, the NOI timed down.
Nope.
So you made a claim, but you didn't come in with the proof of the claim. The SOIs to support your claim.
Well, I came in with the proof because I gave the proof to the judge in chambers.
Okay, what's due process? Did you give notice of a hearing?
I never got a hearing. They wouldn't give it to me.
Oh, well, now they're denying you due process then. If you gave notice, had the SOIs, and called for a hearing, they wouldn't give you a hearing, then now you got some breach of due process violation.
Okay, all right, then I can still reopen that whole thing and go after them.
Yeah.
So you did put in an NOI and an SOI?
Well, the in-chambered one is what I gave to the judge, and it was notification that this was a fraudulent sale, and I gave him all the proof and everything else, that I had a bond that I put into play, and I gave to B of A, and I gave copies of the bond to him and everything else, and he basically didn't respond at all.
You set a hearing. You set a hearing. Call a hearing.
They wouldn't allow me to have a hearing. They denied me.
Now you got due process violations now.
Mm-hmm. Okay. Now I can go after him.
Yep.
Alrighty. Sorry to interrupt you, Jacob.
That's okay.
If you ever get damages that's 4 times the value of what the property was. And you might not be able to get the house back if they sold the house, but at least you can get the value of the house times 4. And then you can bring in punitive and compensatory damages, and you can end up getting, say, $2, $3, $4 million on top of that. Now it's just in straight litigation stuff.
So in other words, I have to go and file a case against the judge now. Is that what you're saying?
Yeah, I would sue the case, sue the previous case, yeah.
Okay. Well, sounds like I'm going to have some fun out in California.
Just a general question, though. Just with that much money involved, there's still no way he can necessarily bring a lawyer, and he's still got to just do that himself, I guess, eh?
Well, I don't know. I wouldn't trust it.
Well, I mean, if you did it on commission, right? Because that's the only way I'd ever look at a lawyer on commission. But would they recognize all the trust stuff on your behalf?
You could try the lawyer route to see what they'll take it or not. I don't know.
I don't trust lawyers.
Oh, commissions. I just don't know whether they'd see it or not, you know? Because, you know, this kind of, when we exercise our thing in trust, it's almost like antithetical to, you know, it's like almost like you don't, you know. That's like the lawyer.
Well, it's in another world. They don't understand it.
Yeah, or they won't admit to it.
Right. They're still in a debtor-creditor type of thing, and, you know.
I think they know about the trust. I think that's what's going on. They've been hiding it from us. Right? Somebody's got to know about it, so it must be the judges and the lawyers. They're the guys that must be in on this. Somebody's got to know about this.
Christian?
Yeah.
Hey, this fellow. When is the best time to compel for discovery and make sure our rights are secured so that they don't deny us or ignore us?
Hope you didn't try the subject matter jurisdiction challenge, then, you know, as you're into the case and answer the complaint.
Okay, yeah. So, I know someone that's going to go on the BK7, that's the bankruptcy 7. Now, I was thinking about discovery. My real question is when is the best time to ask for discovery? That's basically my whole question.
Right after you answer the complaint.
Right after the answer the complaint. Okay, thank you.
Christian, I was asking a general question, just going back to like when you're purchasing the original house and the simple scenario, because I was trying to explain it to somebody. And I remember you saying, like, the bank sets itself up as a beneficiary, and they send you to a title holder because you got to have, they're basically trying to set you up with the third party because they can't be the trustee. So when you go and you sign you sit down, and I'm sure the lawyer must dazzle you with some kind of misdirection to get you to sign that document. You're signing the, I guess it's the deed of trust. When you're signing that, and if the title holder considers themselves the trustee, because that's how the bank's setting it up, what do you become when you sign on to that thing? Because you got the bank set up as a beneficiary, the title holder's acting as the trustee to stealing the title away from you in essence. So what are you as the person? Sorry?
You're the grantor.
That's it.
Yeah, you didn't specify yourself to be beneficiary, so once you granted the property, then you're out of the picture as grantor.
Oh, that's an interesting twist you just put on there. You could actually, if you were quick enough, put yourself in as grantor beneficiary in front of the bank.
Yeah, you could.
You're kidding.
Well, no, and it's just the bank.
The only problem with that is that they wouldn't let the loan go through or the process go through. So that's why.
If you do your trust, though, the way Christian talks about it, that could be a breach issue or something.
Well, you come back 2 days or 3 days later, and then you express it.
Maybe that too. But I guess if you really know your trust, there's something in there, I'm sure.
Christian?
Yeah.
The statutory period for redemption varies by state. In California, wholesale redemption is only available for judicial foreclosure, except where there is a non-judicial foreclosure by a homeowners association. The period for redemption is either 3 or 12 months, depending on whether the foreclosure sale proceeds are enough to pay off the secured debt. If the sale raises enough money, the redemption period is 3 months. If it doesn't, the period is 12 months. In some states, such as California, the statutory period for redemption can be extended if you can show that the foreclosure...
In all states, you just have to go by your state rules, whatever your state is going by. Some places out here, it's like you got a year after the sale to redeem the property. sometimes at sale, you got like, that's it.
So is it better to use a mistake or fraud as a basic?
As a basis for what?
For the redemption.
You're
Well,
supposed
you don't need anything for redemption, I believe. You have the right to redeem the property until the time that you're cut off when the redemption period ends.
Well, I think what he's asking, Christian, is in order to put a claim in, you have to either claim it under some kind of a mistake and or a fraud or unclean hands. Once you put that in, it puts an estoppel to the time clock for the redemption process. In other words, it restarts the process right from the time that you file your complaint or response.
Yeah, early redemption ends sometimes with the sale. So if you can postpone the sale so they don't sell the house, then the right of redemption is always going to be there up to that point. But that depends on your state rules.
Well, the state of California is a non-judicial state.
Well, they're still going by the sale time, aren't they? When the thing is sold. They almost have to. It starts from or ends at the sale date. Let's put that one.
Yeah,
No.
the thing is, when the new buyer on my sister's house, I even notified their lawyers, and I never got a response from anybody that it was a fraud. I let everybody know.
Huh?
So they're even liable for that too. And that's Chase Bank, if I recall right.
I think I might have discovered something here. You know, when we're filing these fraud charges and these complaints, I think that these agencies, they like to have like a police report or a sheriff's report. And it just dawned on me the other day that is the proper sequence of events. Once you file a complaint at the sheriff's department of the county, then that complaint can be acted upon because they have it in their file as a complaint form of which can be acted upon either by the grand jury or by the district attorney's office. If they fail to do anything with it, that would be abandonment of prosecution, of where you can move it to federal court. But you still have the fact that you have a police report or a sheriff's report of fraud or felony.
Yeah, most people don't know how to make a proper claim in the public opinion.
Yeah, and that's why people are ineffective.
And also, a claim in court of fraud takes a heightened pleading.
But when they do foreclose on a house, are they supposed to return the promissory note to you?
Well, if you don't ask for it, you waive it.
No, but if 3 months you go back and you ask for it, are they to return it?
You have up to 3 years.
3 years, okay.
Yeah.
That's probably.
The statute of limitations.
So if you go and ask them to return the promissory note, which was your special deposit,
Claim trust.
huh?
If you claim trust, it would be special deposit.
You can't claim trust after sale then.
Yes, you can.
So if you claim trust and you came back to them and said I want my special deposit back, couldn't you reopen the case that way?
Yeah, but
And
when I get the house,
they breach giving you a tax?
I'm going to take and go after they're not going to disturb the people who were in the house. If somebody bought the house, if the house has been sold, they will not give you the possession of the house back.
But that's not true.
The house was empty and the house is still empty.
No, wait a minute, everybody. Stop for just a second. Christian, that's an error. That's an error. The Statutory Redemption Act says that after the sale and occupancy of an individual, if you come back and prove in a courtroom that there was fraud or some kind of a technicality that redeem that property back to you, they have to deliver that house back to you by law.
But then it might be an issue of they got 90% possession, and if they're peaceful possession, there might be an issue there.
It doesn't matter. It doesn't matter.
You're going to get the house back or the value for the house, one of the two.
Yeah, but
Might settle something.
if you read the Statutory Redemption Act, it says that you have up to 1 year after the sale of that property has been taken away from you. You have up to 1 year in California to do whatever you want in order to get that property back. If, indeed, they gave it to another individual when there was some form of complaint that has already been filed that they knew was that you were going to come back within that statutory redemption period, and if they give that to another individual and the court finds... Huh?
That's after redemption. I'm talking about after the redemption period times out. Once the redemption period is ended, you're not getting the house back.
That's correct. Yes, I do agree with that.
Okay, well, in this case, the so-called realtor that got the listing on the house after they foreclosed on it, there's a retired real estate guy across the street, and he watched them sell the house twice, and in 2 times, it fell through because there was some kind of cloud on the title.
Okay. As long as the sale never took place because they weren't official sales, then fine.
Yeah, I think there's
point
kind of
you made there clear. That's important. The point was that you can come back after the house has been sold, even after the redemption period, and you got no chance of getting the house back. You can still go back and claim trust and get the proceeds and the note back.
Right. Got it. Thank you, because I have one of those myself from 20 years ago when they did this. And you would still go back to the original bank at the time of the trust, or you would go to the one that bought them?
Where it all started. That's where it started.
Christian, I've got a question for you. What about the 1933 Bankruptcy Act under 1491, of where Roosevelt had put a lien against all properties clear across the United States? Now, when they do a foreclosure and do not give notification to the United States of America, are not the banks defrauding the United States of America by not giving notice of foreclosure for them to use original remedy in the name of the person with the Social Security number?
Well, you got to remember that the banks are sub-corporation of the United States, so they're automatically notified.
Everything they do is right.
We didn't go through with a bankruptcy. We just became insolvent, technically bankrupt. That's when they put everything into trust to protect it.
What about this lien that the Roosevelt had put against properties in lieu of the debt, the public debt, that all properties were liened? That means that the title is not clear. The title companies are not giving that information to the public when they buy it. They say it is clear title, and it's not. There's a lien from the government on it.
The titles and terminate the trust is keeping that all.
Christian, can you expound on what you just said, which was we became insolvent, we didn't actually go through the bankruptcy, and that's when they put everything into trust? Can you expound upon that?
Well, technically, Black's Law says insolvency says even though you have the assets, you just stop paying. So you got the assets, you just cease to pay. You could have paid your debt, you just chose not to. But you're still technically insolvent or bankrupt.
So is America bankrupt?
Put their assets into trust. So now they really have to complete the bankruptcy.
So are we in the midst of a bankruptcy as an insolvent debtor?
We still owe the debt. In order to protect the creditors from attacking the beneficiary's assets, that is where the discretionary trust comes in.
We're in receivership, aren't we?
Under the trustee, yes.
Now,
Under the
now
trustee.
listen, guys. I've been doing some international research on that, and the Hague Convention. The latest readout is that they conclude that the convention would not cause foreign law to apply to transfers of U.S. real property to trust. Number two, application of the convention's choice of law rules. That's what you've been talking about, right, Christian? Application of the convention's choice of law rules will have no effect on domestic trust and should not, as a particular matter, significantly change the way U.S. courts currently apply choice of law rules to foreign trusts. And the convention will not enlarge the jurisdiction of U.S. federal courts over domestic and foreign trusts. The purpose of the convention is to enable trusts to operate as legal persons in jurisdictions where they previously have not been accorded legal status, eliminate the possibility that a trustee of a valid trust could be considered to be acting in the trustee's individual capacity. Every jurisdiction within the United States recognizes the institution of the trust and the rights of trust to own real property without having the property rights of the trustee confused with the property rights of the person acting as trustee. The convention simply confirms this fundamental principle of trust law and provides a mechanism whereby the salutary principle may be recognized in countries where this principle up to now has not been generally recognized.
Wow.
Article 8 requires state parties to apply the governing law of the trust only in matters affecting the internal order of the trust, such as the appointment, removal, and resignation of a trustee, the rights and duties of trustees among themselves, the rights of trustees to delegate their authority, and the power of trustees to dispose of acquired assets, the power of investment, restrictions on the duration of a trust, the liability of the trustees to the beneficiaries, the distribution of trust assets, and the duty to account. Article 11 lays down the primary rule of the convention that a trust eligible for recognition under the provisions of the convention is to be treated as a trust. Therefore, at minimum, that the trust property constitutes a separate fund and that the trustee may sue and be sued in his capacity as trustee, and that he may appear or act in this capacity before a notary or any person acting in official capacity. This means, 1, the personal creditors of the trustees have no recourse against trust assets, that the trust assets shall not form part of a trustee's estate in insolvency or bankruptcy. Number 3, that the trust assets will not form part of the matrimonial property of a trustee or trustee's spouse, nor part of the trustee's estate at death. And number 4, the trust assets may be recovered when the trustee, in breach of trust, has mingled trust assets with the trustee's personal assets. So, I was thinking, on an international basis, is a private trust a foreign trust?
Oh, you're reading that. That was off of what?
Is a private trust a foreign trust?
No, I was asking, what was it you were reading from?
Oh, I'm reading from the United States Trust Law and the Hague Conventions on Trust.
That's from the Hague Convention. Okay, international.
Yeah, I'm reading from the Hague Convention.
What year was it? Modern times here? Recent? Pretty recent?
It's recent, yes.
Okay.
Isn't that talking about statutory trusts?
Correct, right. Yeah.
What they're doing is, the reason why I bring this up is because it appears to me that most of the security and pooling agreements of these so-called holders or certificate holders or whatever, that these proceeds that we want to go after, the interest on the bonds, these are pretty much held by international trusts right now that are not in the United States. to end up kicking in and applying here in order for us to get any of those proceeds back.
Yeah, but I really don't care because read 8-507.
Okay.
The one who's liable is the one you make the claim for, or the claim to. If the bank doesn't give me the asset back, they're not liable for them. Read 8-507.
Okay. We'll study that. Another thing is that, we want to hang our hat on our own law form, and we're basing it on this Hague Convention, are we not?
I'm not. I just pointed that out for reinforcement.
Oh.
If you look on original documentation I put into the court, I got 5 case sites to support the grantor of the law.
I saw those, okay.
That was under the restatement.
If anything, it just sounds like it's saying trust law stands, and it's not even having any influence on it. It's just almost pointing it out, almost like bringing it back.
Yeah, the equitable trust law is going to stand, and it's going to take precedence over common law or statutory statutes and codes.
Very supportive of what you're saying.
Well, I was surprised to see all the countries that don't have, they say don't have trust. And Russia,
the whole world. It's really, the full faith and credit is really talking about trust.
full faith and
faith is a breach of trust. Everything's done in good faith, that's trust. That's UCC. Just what I was reading about tonight. Credit is belief and trust. Did you hear that? That's the definition of credit.
It's belief and trust.
Credit is belief and trust. Or belief or trust.
Or trust or in trust?
There's no separation of the semicolon between the two. They're not no ands. They're separate. It's trust. Credit is trust.
That's wild. That's wild.
That's horrible.
So now you got credit and trust, and you got credit in a debtor-creditor world. Now, how do you differentiate? I guess it can go back and forth between both worlds, though, can't it? Because credit's credit, right?
Well, I'm seeing that EC is nothing but one big trust, because it's talking about under 1-304, it said that, the whole setup for UCC is to be done in good faith. Good faith is trust.
Right.
Oh, mirage.
Mirage. It's a veneer.
And that's the CCI information they don't want you to make known, because you'd be rocking the boat. So they come up with these FTC regulation and rules and all this stuff to keep it so that it's private, because it's keeping your CCI information private, because they don't want this in the realm. And really, it would be a breach of trust. It would be antitrust.
So would that be the same in mortgage cases when they have Truth in Lending Act, Real Estate Practices Act, blah blah blah? Those are all the same type of thing where they're trying to keep people from seeing the trust.
That's the point I was trying to make. All of UCC, if you give them into anything, even under USC, the code, United States Code, that is for good faith. If you get anything that's in bad faith is a breach of trust. That's antitrust.
Antitrust, bad faith.
got antitrust, you've got monopoly, you've got good faith is confidence. Bad faith is a breach of confidence. That's a breach of confidentiality. You see the chain, the morphing of the words, and being able to connect the dots is a breach of credit.
A breach of credit.
Yes, it's a breach of credit. That's a breach of trust.
Christian, going back to that original model we were talking about earlier, where when we signed the deed of trust and the bank's a beneficiary and the title holder is set up by the bank to be a third-party trustee, and you're saying you're basically just signing as the grantor, but at some point they put it back on you as the trustee because that's why you get all the obligation of the mortgage when you don't know better to of course step up and express the trust.
From the county, because you're trustee on the county.
Sorry, you're a trustee on the county?
Yeah, the county warranty deed on the deed. You're formed a trust on the county then. You're trustee on that county then.
Okay. How many trusts are there going on then? You got the first trust when you're established, basically when you're signing the document. There's another trust there again?
There's at least three. County, the escrow, and the bank.
And the escrow one?
And the escrow, the title company, that's a trust.
That one you're just the grantor. That's where you're signing and they're being the trustee and the bank's being the beneficiary of that one. Right?
Well, you may be dueling it, so it kind of depends on which way you look at it. There's between 2 to 3 trusts here, operating simultaneously or more,
There's got to be one on the credit application.
Yeah, that could be the other one. There's at least.
I think credit application tied to the international banker.
Every trust that's there, must be tied to, in order for it to be a trust and to come into existence, it has to be, your signature has to be there somewhere, right?
Yeah, signatures, right.
So I can see the one signature, and I have heard that, in fact, because I've been asking around about that document, the deed of trust, because I still think that people, are not signing it, because I found talking to people, nobody even knows which page they're signing on, but I have heard from someone, they said, well, there's a whole bunch of signatures, and the thing, it's like a dossier, there's so many pages to it, right? So you're creating, is that what you're creating?
Yeah, you might be having a trust on each signature.
Oh, you must. Every one of those goes to agency and goes to securitization. Every one of those signatures.
But credit in Black's law was number 1, belief, and then semicolon trust. And the jury gave credit to Benson's version. And 2, one's ability to borrow money. The faith in one's ability to pay debts. That's trust. So credit is trust.
i.e. credit report and all that stuff.
Yeah, confidence.
The credit report. So, Christian, can you help us understand the escrow trust?
Help you understand the escrow trust?
Yeah, you said the first one is escrow, and that's the title company. And they're
the bank of power, and they appointed the title company for you to close the escrow.
Who appointed
trusteeship. Where it goes from there, I don't know.
So the title company ensures that the title is clean.
Yeah, what's insurance? Bond. Bond.
Okay, bond. So the title company bonds the title.
A bond is trust.
Bond is trust. So the title company has a trust, and the title is a bond.
And I think they're just like the bank knew they had to have a third party because they were beneficiary. They needed a scapegoat, and that scapegoat is the title company. And this title company is under the disguise, and everybody thinks that they're checking out to make sure there's clear title. Ain't got nothing to do with it. Their trustee to pass on to the bank is not trustee and beneficiary, and they terminate their own trust.
Okay.
Nothing to do with title stuff. Everybody's got a little.
Okay, but when they're taking the title as trustee for the bank from the seller, the seller had a mortgage, and that.
You're talking about the county now?
Huh?
You talking about the county?
No, I'm still talking about the escrow trust.
Okay.
So when the title company is the trustee as the scapegoat for the bank, he's getting the title from the seller, right?
The title from the seller. Yeah, well, right.
Okay, now the seller has a mortgage and a promissory note scenario where the titles are split. And he doesn't have a perfect title that he's bringing into the picture. He's got a split title. Huh?
Isn't he getting the title from the purchaser? Because isn't that what you're doing? You're signing a transfer of the title over to the trustee.
Right, probably. Really recorded in the county.
Who was saying that the wording in that document, you're already the owner?
The title never leaves the county. It just gets switched from one account in the county into another account in the county.
Oh, just like an auto.
It's a successive trust under what is it called? The privity of the state.
Privity of the state.
Privity of the state definition. I've got it right here.
It's the breaking down of one trust and the creation of another, isn't it?
Well, it's just a transfer of the same title.
I thought it was always the transfers going from the person who's signing it because the wording in the document was that he already is the owner, and that the only reason why he's filling out the deed of trust is because he's transferring it now back to the title holder, creating another trust.
Privity of the state means a mutual or successive relationship to the same right and property as between grantor and grantee or landlord and tenant. That's the county warranty deed.
Okay. So, but he is opening a new insurance policy on it?
What's insurance policy? Trust. It's a successive trust relationship.
Isn't there a point in between though where just for that, before he signs, basically that guy's owning that property?
And when nobody's taking it out of the trust account, they're just switching it from one account in the trust to another account in the trust.
But that's not, the trust doesn't come into existence until he puts his signature on there and basically acknowledges his incompetence, which gives the title holder, the trustee, the right to construe it and take the title from him.
Yeah, you end up being
saying, though, that there's a brief point where it looks like that title's open or not in existence.
But could they be using the credit application to make that transfer?
Well, you could have generate the funds as negotiable debt instruments to get you liable for it so they can have the money there for closing.
Okay. Well, I mean, you're paying for title insurance, are you not?
It's insurance. Trust. All
Okay,
trust is insurance. It's all trust.
But you're selling you a defective title.
You're doing an insurance. An insurance of what? That you're going to do your promise. What's a promise? That you're going to do your trust.
So insurance is just another cover word for trust. Trust isn't insurance. Insurance is trust.
Yes. Another onion skin to go down and hide the truth.
Yeah.
Christian, isn't there any remedy in the fact they didn't deliver you a whole title? You paid title insurance to be assured that you had a whole title, and you didn't.
I'm just thinking about this.
There's no liens up against it. It's not a clouded title. There's no discrepancies in the meets and bounds, or the rods and the new grade, the rods. Thank you.
I'm just thinking of this. I've heard we were talking about trying to deregister vehicles, and we're thinking, you know, it's funny because you sell a vehicle and you got to sign the ownership before you sell it to someone else, which is basically releasing the registration, which I think is how they get the trust in the first place. And then that person's got to
transferring titles on a successive trust again.
Yeah. So in between, before that guy goes back to the registration office, technically it's unregistered, and just like in a metaphorical way or comparison way, that if he was going to do anything, that would be the time to do something, because like until he goes back and signs it, re-registers it, it's out of, the trust is not being held by the state there in that example.
I think it's still held in disguise or escrow, but it's really still held in trust until the new owner signs the transfer papers and then transfers them to him right at the same moment. So it just goes from one trust to another.
So you think there's a continuous trust there?
Yeah, successive trust.
How do we handle that in our original insurance then?
Handle what?
How do we handle this commingling or this mingled successive trust at the county? How do we deal with that, with our indenture, with our expression of the trust from the get-go?
Well, they're not commingling anything hardly. They're causing us to be the ones that breaches it because we're commingled.
So we don't have to express something about that when we express the trust anywhere along the line. We don't have to
look at when they don't give the note back or make a demand, now they're in breach. But they're not commingling our funds, our assets and things. They're taking perfectly good care of them.
So you can go in there, Christian, could you go in there and sign, put by, full colon, and then the signature, right? And then the next day, because somebody said, basically to push that paperwork through, they come back the next day and say, now I'm going to take a grantor position. See what I mean?
Do that. Take grantor position to do anything.
And then if they say what, then you just point at the ellipsis. Technically.
Christian, do you have a pencil?
I got a pen.
The guy's name that you were trying to think of the other day is Chris McLaughlin.
What was that now?
A gentleman asked you 2 days ago about the lawyer that you had mentioned that teaches other lawyers, and you couldn't recall the guy's name that you had mentioned. The name that you had mentioned is Chris McLaughlin.
I did? I don't remember.
Yeah, you did. Yeah, you were trying to remember this guy's name, and then I inadvertently heard you speak about the guy on a recording, and so I wrote it down and made a note to mention to you because that might help trigger your memory what importance it was to you. It was Chris McLaughlin. He was a guy that teaches other attorneys about whatever the guy was at of the call 2 nights ago.
I don't remember his name. Doesn't ring a bell.
Okay. So, Christian, I guess the summary of the escrow trust is that it's terminated.
The escrow trust is, well, the trustee, he ceased being the trustee. That trust might not have been terminated. But his duty as trustee, because he was just still there to be the disguise so that the bank wouldn't be trustee. And as soon as you signed the note, he shot it to the bank.
And the bank
formally was trustee, so the bank couldn't be trustee and beneficiary simultaneously.
No, I understand that. But so now is it a terminated trust, or is it a trust that doesn't have a trustee, or did the bank?
Well, I'm going to put it as terminated because I'm going to fire the guy.
You're going to fire the guy from the escrow trust?
Yes. My power of attorney created this position, so I'm going to take the position away.
Well, who do you notice for that? The bank?
Now there's no question that, I'm going to appoint another trustee, like the bank.
And what would that trustee do in the position of the escrow trust?
Nothing. His job position's done. I don't have any beef with him.
No, I know that, but it's not terminated. The trust, you said.
Right. But the trustee position, what the trustee position is.
What's his duty then?
He doesn't have a duty. He's terminated.
His duty is terminated, but the trust is not terminated?
Correct.
So there's an escrow trust. Are there funds in it?
I don't think so. It was transferred over.
Are the payments that the beneficiary is collecting every month, are they in an escrow trust?
Yeah, they're probably coming out of the payments that you make.
Right. So haven't they set up an escrow trust for those monies?
Probably there's an escrow trust put up, yeah, and then they're taking a percentage of it.
They're entitled to a percentage of it. So when we ask for the proceeds back,
agreement, your PSA and all that stuff, but I've terminated that too. I revoked that.
What's PSA?
The pooling and servicing agreement.
Well, the pooling and servicing agreement. Oh, you terminated that also?
Sure. When I got the debt validation dishonor, that gave me the right to terminate all the contracts under this so-called debtor-credit relationship.
But do I have to notice the pooling and servicing agreement companies?
Got to notify all parties, that are involved that you know of.
So what if the bank is unwilling to give me who the pooling and servicing agreement parties are?
But then how are you going to serve them then?
That's my point.
Well, you can.
How am I going to get the bank to tell me who the pooling and serving agreement are? It's hard enough to try to get them to tell you who the frickin' lender is.
Just report it to the SEC on a 15 and 25.
Sleep signs rights has no rights. In other words, if I don't know my rights, I don't have any rights.
Well, that's why I'm asking questions.
Yeah. We've all been sleeping too long, including myself.
Yeah.
Notice to the principal is notice to the agent. Notice to the agent is notice to the principal.
That sounds great, but I'd rather be a lot smarter than that. I'm not going to hang my laurels on that frickin' statement. I want to know who they are. I want to nail them to the cross.
Hey, you guys, I'm going to get off the call. I'm going to stop the recording. Anybody who needs a copy of it, just let me know.
Thanks, Chris.
Yep. Guys, have a good evening.